Have I not kindly to mention one matter? I'm on notice. My lord, this is the matter regarding Group 1, ready for hearing. My lord, reason for mentioning is that the writ petitioner before my lord is a lady.
Is there?
The lady
Okay.
approaching 90 years, my lord. Only for the reason, my lord, if something goes wrong, God forbid, my lord, my writ petition will become infractuous. What I'm only seeking, I'm seeking for some precedence. If my lord kindly fixes the matter any day pursuant to a lord's convenient, any day, top of the list. Any day.
No, I have very few matters in group 1. I can dispose of the matter. If the matter is ready, so what is the...
Chief Minister is leading the my lord. We are ready in the matter. Immediate Monday, Tuesday, whatever is convenient for my lord.
What is the status of the pleadings?
Complete, my lord.
Complete.
Affidavits are complete.
Affidavits complete.
I've served notice, my lord. I'm on
Thursday.
top.
Next Thursday. Not top. It would be appear according to the list.
For something.
Let it be listed first, thereafter I will
It's
take.
already in the list. It's item number.
It is
28.
already on the list.
Yes, yes. In today's list is item number 28.
Item number 28.
Yes, sir.
It can be taken up today also. You just wait. It can be taken up today also. There are several adjournments there. I know.
The only thing is that Mr. Mitro, due to some personal reason, is not coming to court today.
Let it call today.
I will be
Okay.
here.
You will be here.
I
Just
will be. I will be.
very well.
Your Lordship, may I have Your Lordship's kind leave to mention a matter, Your
It is
Lordship?
not the day of mentioning.
Your Lordship, I bowed down to Your Lordship. This is an assigned matter, Your Lordship. I am only mentioning for extension of interim order. We have filed a CAN application for
Extension of
extension.
interim or what?
Your Lordship, this is an assigned matter. Your Lordship has stayed a proceedings.
Assigned matter.
Your Lordship, this is an assigned matter. Group 3 matter, Your Lordship.
Whether it is listed? No, first time.
Your Lordship, this, it is not today in the list. Your Lordship had passed an order on 15th of January, Your Lordship.
Group 3 matters, it was not listed, I think, not assigned to me.
This is assigned.
Second. Group 3 matters. Okay, I have passed the order.
Your Lordship.
Group 3 matters আমার কখন দেখি দেখে নিন মার্ক করুন Monday to mention.
Oblige, Your Lordship.
Your Lordship, I am praying for mentioning in the inclusion the daily list under group 8.
Group 8 matters.
Yes. Your Lordship,
Monday.
it's an urgent
Mention
matter.
it on Monday. What is the urgency?
Urgency that the petitioner concerns a grant of lease for a fair price shop, but he has fulfilled all the formalities, but due to shortage of his godown, his license has been blocked. And group respondent number 8, even though with infirmities and anomalies, he has been in a verge of getting the license. If he once he gets the license, due to the vacancy notification, there is only one post. If he gets the license, then the suit will become infractuous.
So have you preferred any writ petition?
Yes, sir.
Whether it was listed or you
No,
want
Your Lordship, it is not listed in the daily list.
when you file it?
Your Lordship, I filed it previous week.
Previous, then it will appear on Monday under the motion matter. It
Monday.
would appear regularly.
Kindly take it as per your convenience. If you could.
When you file this, when you file the writ petition in the previous week, then it would be appear on Monday. Regularly, it would appear on Monday under the motion. Okay. If it is not appear, you mention on Monday.
Will I submit?
No, just keep it yourself. Call the list. Oh, huh?
Filing my affidavit of service, but challenge করে the selection.
Department again.
I must be candidate, my lord.
So far the state is concerned, that I have served. And so far the private respondent is concerned, we have served, but it has not been received. Considering the urgency, your lordship, fix the matter today.
But the difficulty is that I have been entrusted with the matter. Now the GP office is now still not operating. So I do not have
My lord, just
kind.
the case, my lord, a vacancy has been
No,
notified.
what about the private respondent? Have you served?
Yes, I have served, my lord. License has not been granted. But yesterday, Tractor Court said it has not been received by him. Not updated, sorry, my lord, not updated.
Then service has to be
11th.
completed. So when can-
Since the urgency is involved, my lord, if I have faced your lordship, the case, it's a peculiar case where my lord, ADM has interfered with the entire selection process this year. Just I am giving 2-3 documents. Kindly turn to page 19. It's the vacancy declaring notice. Kindly see the date. 8th of January 2024. Have you looked?
Mr. Sir, I understand, but without serving the all respondents,
Even I am
All
not
these
in a
matters,
position
state has
to
been
assist
served.
your lordship, my lord.
State has been served.
I understand. State has
But
been
so far
served,
the
but
private respondent is also, I must be candidate. But unless there is an interim order, protection for 3 days, 3 days I shall pay. And if I show your lordship how and which manner this selection process has been continued, if your lordship will be satisfied and should be passed an interim order,
Then-
just allow me, my lord.
okay.
But may I say only one thing? Instead of passing the interim order, formal interim order, let the matter taken up on the Monday, my lord. In the meantime, I will speak to the military officer. I will assure this court that no steps would be taken in pursuant to this vacancy
Record it.
vacancy concern.
Record it.
Kindly
Record it.
do not. I will take the responsibility. I will speak to it. If it
My
is
lord,
not
on
already
Monday, your
been
lordship
done, if it is not already been done, from today I am taking.
cannot be appear on Monday because it is a Jalpaiguri bench matter.
हाँ तो जलपाईगुड़ी
So
से
some protection may be given for 3 days since that has maybe recorded.
No, Monday, Jalpaiguri, there are benches.
Yes,
Okay, there are benches.
that's the difficulty.
So that would be appear before the bench.
No, millet, in that event, I have to take instruction. At least I have to make my submission.
I
You have
understand.
paid for Rule 26 also, my lord. Kindly consider the urgency of the involved in the matter. If the license is granted, my lord, in the meantime, if my learned friend give an undertaking that they will not proceed with the matter any further, at least for 7 days or 3 days or 5 days, so that we can take steps to appear the matter before the Jalpaiguri bench.
Lordship kindly takes it up at 11:30.
11th.
11:30, so that I can come back in the meantime and I assure the court what steps we would take or we will not take.
11th means?
No, 11 today.
Okay.
11:30 today.
Okay, 11:30.
11:30 today.
Okay, very well. You take instruction.
11:30 today.
Take to instruction.
হ্যাঁ এই না হলে কি করে পড়বো?
Okay, pass it over.
Come back at 11:30.
Yes. Pass it over.
Item number 5, my lord. I am for the petitioner. On the last occasion, my lord,
Yes.
lordship directed to produce certain judgments with regard to, my lord, the acquisition of land and the employment. But kindly, my lord, I am placing one judgment, my lord. Sanjay Mitra versus Khalilan. The citation is 2007 SCC online CAL 452. Paragraph number 3, my lord. If I read the paragraph number 3, my lord,
Yes.
I feel that instead of reiterating the facts once again for convenience, let my judgment and order dated 14th of February 2006 be reproduced below. For the purpose of setting up a Bokreshwar thermal power station, huge area under the district of Birbhum was acquired by the state, resulting in the loss of agricultural as well as the homestead of the villagers in a substantial part of the said district. The state government decided to give employment at least one from each landloser's family. A committee was set up under the chairmanship of the district magistrate for preparation of a panel of landlosers. The said committee consisted of several members from different fields, including representative of West Bengal Power Development Corporation Limited, under whose control the said thermal power station was set up and put under operation. On October 17, 1977, the Labor Department of the state of West Bengal issued a notification wherein all government employees, including employment in local bodies and government undertakings, were directed to be routed through employment exchange, and the employment exchange was asked to categorize inter alia the persons who were uprooted from their homestead or whose inter alia the or whose uh, or whose agricultural land was taken away by the government for development work in various parts of the state. Those persons were placed by the employment exchange in a special category named as exempted category. 30% of vacancies were earmarked and reserved for exempted category candidates by a subsequent notification dated April 27, 1979. On October 14, 1980, the government made provisions for direct absorption of the land losers without any reference to the employment exchange. There were subsequent circulars favoring consideration of appointment of the eligible candidates from the uprooted families of the various parts of the state. 52 writ petitioners listed their names in such categories subject to scrutiny of the special committee formed under the chairmanship of the concerned district magistrate. Even then, they were not being considered for employment. They approached this court by filing writ petition so and so, wherein Justice Altamas Kabir, as his lordship then may by his lordship's judgment and order dated November 24, 1999, disposed of the said writ petition by recording that submission of the learned counsel appearing for WPDCL to the effect that after following the procedure of empanelment of such land losers and the intention of providing with the intention of providing employment, the names of the petitioners have already been empaneled and they will be provided with employment as and when their turn comes according to the serial number in the panel. On plain reading of the said order, it is clear that according to WPDCL, all writ petitioners in the said writ petition have already been empaneled and they would be provided employment as and when their turn comes. Employment was, however, not given to 52 writ petitioners despite series of representation made from time to time in that regard. Real game started thereafter. A cooperative society was formed in Bokreshwar with several land losers as well as the outsiders from the neighboring villages belonging to a particular political party to which the petitioner did not belong. The said cooperative society was entrusted by WPDCL to supply unskilled laborers for working in the plant. From the original list, 45 persons were given appointment without following seniority. It was alleged by the petitioner that they were superseded as they belong to a particular political party opposing the present government in the state. There has been series of meeting and representations to resolve the controversy. However, nothing fruitful happened. Second writ petition was filed on May 16, 2003, being writ petition so and so. The writ petitioner was initially moved before Honorable Justice Bhaskar Bhattacharjee, his lordship, by his order dated May 23, 2003, restricted WPDCL from appointing any unskilled labor without considering the eligible petitioner. Matter thereafter came up before Lordship Arun Kumar Mitro after change of determination when his lordship extended the interim order passed by Honorable Justice Bhaskar Bhattacharjee. His lordship also directed the district magistrate to prepare a list as per the scheme and send the same to the concerned employment exchange. The district magistrate was asked to submit a report to the court. His lordship reiterated that no appointment would be given to by the company till the report of the district magistrate was considered by the court and necessary order was passed thereon. The matter again appeared before his lordship on September 23, 2003, when his lordship recorded that the district magistrate, despite order of the court, did not submit any report. An application for vacating the interim order has been made by WPDCL, which was heard by Justice Jayanto Kumar Biswas on December 16, 2004, when his lordship gave direction for filing affidavit. The matter thereafter came up to me for hearing. I heard the writ petition. In the course of hearing, I passed an order dated February 24, 2005, when it was submitted on behalf of WPDCL that they wanted to engage unskilled laborers through contractor, and for that they floated a tender. The petitioner informed the court that they also applied for setting up a labor cooperative society, to which I directed Mr. HON'BLE Haq Learned Counsel appearing for the state to take instruction from the cooperative department with regard to the registration of petitioners cooperative society. The writ petitioners, along with the application for vacating of the interim order, was ultimately disposed of by me by judgment and order dated May 17, 2005. I recorded that the district magistrate submitted a report in court wherein it appeared that out of 52 writ petitioners, one appeared before the district magistrate. As such, he was unsuccessful in completing the process of scrutiny. I also recorded the submissions of the same learned counsel appearing for WPDCL, who made earlier submission before Justice Altamas Kabir to the effect that WPDCL was in dire need of manpower to complete the extension program which they had undertaken with foreign collaboration, and because of the order of injunction, they could not proceed in the matter. An impression was given to me that as if WBPDCL intended to appoint unskilled labor force, which could not be possible, firstly because of the order of injunction, and secondly because of the non-cooperation on the part of the petitioner.
This is an order of contempt application.
This is order of contempt. Now,
Lordship, I am not disturbing my learned friend. Against that, we preferred an appeal and contempt order has been stayed. Sanjay Mitra matter, it has been stayed.
now it kindly comes to the next page once.
No,
The-
what is the status? What you want to say?
From this, my lord, in this judgment, they made categorical submission before this court that as per the list that will be provided by the district magistrate, they will follow the seniority list and they will be giving recruitment to the petitioners as and when their name will appear
No,
in the list.
the issue is completely separate in this matter. There are some groups who political involvements are there.
That
They,
in that
they,
matter, my lord,
the petitioners are not given the opportunity to get unskilled laborers.
the
That's
lordship
why it was moved before this court.
kindly comes to para number 22 once. The Learned Council for the Corporation undertook before this court that they would give appointment as per the list, strictly maintaining seniority. No such appointment was given after my order dated so and so. The corporation thereafter continued to engage unskilled labor through cooperative society, allegedly having patronage to a political party, being power as and when the matter appeared before me.
This
So-
matter is not before this court.
No,
Though-
Kindly see next line, my lord. Kindly see the next line. Corporation took the plea that list was not forwarded by the district magistrate. This was the plea taken at that point of time, since the list was not forwarded by the district magistrate. Now, my lord, already, my lord, in my case, the list has been forwarded by the district magistrate to the corporation. Now, my lord, as per the seniority list, as per
No,
their
I want to know the law. What is the law declared by the court? Because there are two status of the petitioner. One by as a person under exempted category, and another is under land losers.
under the land.
Under the land losers. That is 1998 notifications.
My lord.
So what you want?
I want employment, my lord. Whether
No,
under
I understand you want employment. You are enrolled as a exempted category. So
them,
the
my lord.
state will do.
let them
the-
produce the list of the candidates who, whether my name is featuring in that list or not. From that
What
list,
list?
the list that they are maintaining as per seniority, they are giving recruitment. Now, my lord, if they produce that list before this court, from that list,
List by whom?
list
who-
maintained by the WBPDCL and the
No. WPDCL has not maintained the list. List maintained by the concerned department of the government.
that is the power department.
No power department. That's why I am just asking you what your status you want to place as a exempted category. If you are exempted category, there are a list, empanelment list by the concerned department.
Already, my lord, my name is appearing under the exempted category. And
That's
also,
why I am asking what you want. If you want, I can speak. I can pass a specific direction upon the department concerned who is maintaining your list, that your name, the
my
name
lord,
of the
let them
petitioners
produce
may
the
be.
list before this court.
Yes.
Let them produce that list before this court, because I have to know, because for the past 27 years,
Have you made them party? The department?
labor department has been made the party. My
No, labor department is not the department. No.
lordship is talking
Kindly
about
consider 3 pages I will show. My learned friend's client are clamoring for 27 years. They are from 2000, from 1994. Lordship, kindly take the trouble. Page 29. The admit card of my learned friend's client. His date of birth is 2nd March 1994. So 1994. Lordship, kindly take the trouble. 29, page 29. West Bengal, this is the Madhyamik admit card.
94.
94. So the notification of 1996, my learned friend's client was 2 years. Lordship, kindly consider page 25, 96 notification.
Ballot, the notification says that
বলেনি
one
আপনি
member.
আপনি তো বলে নিয়েছেন, আমি বলি এবার একটু জাস্ট কেস ল গুলো জোসেফ জানতে চেয়েছিলেন, আমি দেখিয়ে দেবো। পেজ 25, first line, least this committee is for 2 years. Next page, Lordship, 26, 98, this committee was for 2 years. So in 1998 my learned friend's client was of 4 years. Now exempted card, your lordship will find, lordship, prior to that, your lordship kindly take the trouble to consider 27. So 98, whatever committee was there, that was prevalent, let us suppose up to 2000,
Yes.
up to 2000. Then page 27, I have handed over the notification before your lordship, 21st August 2022,
2002.
2002. So everything has been given a go by. Now your lordship kindly take the trouble to consider page 73. Admit 73, admittedly, my learned,
Exempted category.
yes. So my learned friend's client has taken advantage of the notification of 2002 and got his name enrolled in 2020, 2015. Not prior to that, but because he cannot. He could not reach the age of 18 years. Now, lordship, kindly take the trouble to consider. Last day I was respectfully submitting before your lordship that when the land has been acquisition by the government, and as per the law, your lordship knows better than me, when acquisition is there, he was of 2 years of age at that point of time. Now his heirs must have been got the compensation. So far as if my learned friend's client wants to bank on 96 or 98, then I am covered by this judgment of this honorable court, 2002 1 CHN 404. This is of division bench. Lordship, kindly consider same thing happened. And the honorable division, the learned single bench was kind enough not to accept the writ. They went in appeal. Lordship, kindly take the trouble to the last page, the flagged one. Facts are similar. At that point of time, West Bengal Power Development Corporation was not there. It was WBACB. Under one umbrella, everything was there. Now it has been segregated. The power generation is under West Bengal Power Development Corporation. 5 generation units are there, and distribution is under WBACDCL.
Yes.
Now, lordship, kindly take the trouble to 406. It was pointed out, may I place before your lordship? It was pointed out by the learned single judge that in a manner for obtaining a writ of mandamus, the petitioner must establish the existence of a legal right and corresponding legal duty. It was pointed out that it was a matter of policy decision of the state that does not confer any legal right on the petitioner to seek appointment. It may be held that at that point of time some benefit was given to such land loser, but that cannot be considered to be conferring right for all times to come to give employment to the land losers. Giving employment to land loser is a matter of concession and such concessions cannot be enforced in a writ petition. However, since the concession of offering employment over and above the payment of compensation to such land loser was only in the nature of concession, and such concession cannot be enforced by a writ petition, the state cannot be directed to be overburdened for giving employment to these petitioners over and above the compensation already paid to them. Hence, we are satisfied that no case has been made out made out to interfere in these appeals, and we confirm the order passed by the learned single judge. So if my learned friend's client wants to rely on 96 or 98, although he was of 4 years and 2 years and 4 years, he is barred by this because his family member, when the land was taken, got the compensation. Now the thing is, my learned friend's client has enrolled his name as land loser. Now, Lordship, kindly take the trouble. The judgment, the recent judgment I am showing, the same thing what my learned friend is stating here, all have been discussed. Lordship, kindly take the trouble to consider page 6.
Yes.
The learned advocate, has the Lordship got it? Flagged one. The learned advocate appearing on behalf of the West Bengal Power Development Corporation submits that the cause of action of the instant case arose prior to 1980, when the land of the predecessors in interest of the petitioners were acquired by the government. The same fact, because 1994, my learned friend's client has come to earth, and his predecessors in interest, the land has been given and got the compensation. On acquisition of the land, compensation had been paid and accepted by the land loser. The predecessors in interest of the petitioners, being aware that their names were not included in the list prepared by the local committee, that 96 and 98 is a local committee, the committee. Land Advisory Committee, for the purpose of providing employment, approached this court in 2000, and the Honorable Bench passed a specific order in that matter. The Honorable Division Bench, after taking into consideration the facts of the case, was pleased not to pass any mandatory order in the matter and had only expressed hope and trust that the left out persons shall be considered by the selection committee as and when they are found suitable, an appointment may be given to them. It has been submitted by virtue of the notification dated 21st August 2002, what I have just handed over before the Lordship on the last occasion. The state government, the state of West Bengal, exercised the powers conferred under the West Bengal regulation of recruitment in the state government establishment and establishment of public undertaking, statutory bodies, government companies, and local authorities Act 1999, and declared that the persons belonging to the families of land loser in the exempted category. By virtue of the said notification, the earlier circulars and executive orders issued by the government time to time relating to employment of the persons under the exempted category were suspended. My learned friends is contending it is not the labor department, it is the power department. The Honorable Court has said all executive orders passed by different departments. In the said notification, it has been mentioned that for the purpose of enlistment of the eligible persons in the category of land losers, the government may constitute a screening committee. The said screening committee will prepare a combined list in order of priority for the families affected by acquisition of land and forward the same to the district magistrate concerned. The district magistrate shall forward the list of eligible person to the director of employment for enrollment of their names in the exempted category cell for the purpose of filling up the vacancy reserved for the exempted category. The appointing authority shall write the director of employment exchange for the names of the candidates, and the candidates should be satisfied, should satisfy the qualification and other requirement prescribed for recruitment to the post. It has been submitted that since the notification of 2002 supersedes all the earlier notifications, there is no scope for giving appointment to the petitioners directly at this stage. All government employments are made from the candidates whose names are sponsored by the employment exchange. Pausing for a moment, on the last occasion, your lordship was kind enough to put a question to me whether the recruitment of High Court administration, this has been done or not. I have got a notification from them that the Honorable Court's administration has asked for it, and in 2024 the names were sponsored. I will show it. It has been submitted. It has been submitted that the petitioners are in fact praying for execution of the order passed by the Honorable Division Bench. There is no explanation regarding delay in approaching this court. Lordship, the same thing. My learned friend's client was in 1996 was 2 years of age, and 1998 4 years, and 2015 his name was enrolled. He approached this Honorable Court in 2022, I believe. The respondents rely upon the decision delivered by the Honorable Division Bench of this court in the matter of Abu Bakr, Lordship, just now I have handed over, wherein this court held that giving employment to the landlooser is a matter of concession, and as such, concession cannot be enforced in a writ petition. The concession of offering employment was over and above the payment of compensation to the landowners. The state cannot be directed to be overburdened for giving employment to those petitioners over and above the compensation already paid to them. Lordship, pausing for a moment. At that point of time, 2000 notification did not come. So under 2000 notification, 21st August 2000 notification, under the 1999 Act, a right has been accrued in favor of the landlooser to become an exempted category.
Yes.
And for that, a list has to be maintained. From that list, the employer, the organization will ask for it and they will send it serially. Now, Lordship, Arun Kumar Manna, this case, the same point was taken up. Since the matter is pending before the Honorable Division Bench, I did not cite this thing, but Arun Manna is on the same point. Now, Lordship, kindly come to page 8.
Yes.
I have heard the rival contention. Has your Lordship got it?
Yes.
I have heard the rival contentions made on behalf of all the parties. The land appears to have been acquired long prior to 1980. The predecessors in interest of the petitioners approached the court in 2000. The Honorable Division Bench, after considering the matter in detail, was pleased not to pass any mandatory order upon the respondents for consideration of their prayer. It was only a pious wish and the trust of the court that the case of the appellants would be considered for appointment as and when the vacancy arises. The petitioners are seeking a direction upon the respondents for providing them with employment. The said prayer is not made on the basis of observation made. The said prayer is made on the basis of the observation made by the Honorable Division Bench. Had the petitioner been aggrieved by action of the respondents in not complying with the order by the Honorable Division Bench, they ought to have approached the court within the specified time. It is settled law that delay defeats equity. The petitioner, after the order in the year 2000, did not take any step for executing the order, neither did they take any step for exercising their rights, which allegedly accrued in their favor by virtue of the said order. The only explanation forwarded by the petitioners approaching this court at a delayed stage is that the respondent corporation issued appointment letters in favor of similarly situated persons even after 4 years from the date of the passing of the order of by the Division Bench. The statement of the petitioner is not supported by any document. The respondents have categorically denied the contention of the petitioner and have submitted that after publication of the notification in the year 2002, no appointments have been made, no appointments have been given in favor of such land loser, dehodes the guidelines as laid down in the said notification. The court is not supposed to conduct an inquiry to verify the allegations made by the petitioners regarding appointment of the land loser as such a delayed stage. It is for the petitioners to approach the court with all possible evidence in support of their stand. Without any proof to substantiate their claim, the appointment has been given by the corporation after 4 years of the order passed by the division bench. The same cannot be relied upon, and as such, no order can be passed on the basis of such submission. The petitioner submitted that since there is no time limit for filing application under Article 226 of the Constitution of India, they are entitled to approach the court at any point of time. It is true, there is no time limit specified for approaching by the Honorable Court under Article 226 of the Constitution of India, but it is expected that a litigant should approach the court at the earliest opportunity available. As the relief under Article 226 is a discretionary, it is for the court to take a call whether or not the exercise of discretion in case there is inordinate delay in approaching the court. In the case at hand, though an order was passed in favor of the petitioner in the interest of the petitioner in the year 2000, the petitioners did not show due diligence to execute the order within the time limit specified. The petitioners practically slept over their right for a considerable period of time and not approach this court in the year 2010. By that time, the circular which the petitioner was relying upon for obtaining the employment had been superseded by the subsequent circular of the year 2002. Then the decisions are being discussed. I am not troubling your lordship. Kindly take the trouble to page 10. Page 10, last para. The Honorable Division Bench, has the lordship got it? The Honorable Division Bench of this court in Abu Bakr Siddiqui categorically held that giving employment to the land loser is a matter of concession which cannot be enforced in a writ court. The Honorable Single Judge of this court in the matter of Arun Kumar Manna, Supra, has considered the said matter in details and has pleased to dismiss the writ application, which is now pending before the Honorable Division Bench. That's why I am not troubling your lordship.
Yes.
With that. No stay order has been passed. The petitioners persistently harp upon the point that the judgment delivered by the learned single judge in the matter of Arun Kumar Manna, Supra, will not be applicable in the instant case, as the issue of estoppel was neither raised nor considered by the court in the said case. It has been submitted that the government had made a promise of giving appointment to one of the members of the family of the land loser. The petitioners already acted in terms of the said promise, and by virtue of the order passed by the Honorable Supreme Court, the promise is bound to carry out his promise, and the promisee is entitled to challenge the inaction of the promiser to act in accordance with the promise. As the promiser did not act in accordance with the promise and did not give employment to the family members of the land loser, the petitioner is highly prejudiced. The aforesaid submission of the petitioner is absolutely fallacious. The scheme of employment was published long after the land was acquired by the government. In the proposal of acquisition of land, there was no promise for giving employment. The land loser was given compensation on acquisition of the land as per law. The scheme for employment was introduced long thereafter. At that point of time, the acquisition of land, the petitioner could not have anticipated that the government would come with a scheme for employment in near future. No right accrued in favor of either of the petitioners, predecessors in interest of the petitioners or the petitioners herein to get employment on the date of notification of acquisition was published. Incidentally, the petitioners herein and the petitioners in Arun Kumar Manna Supra both are claiming employment on the basis of the order passed by the Honorable Division Bench in the year 2000. On similar facts and circumstances, the Honorable Single Bench dismissed the petition filed by Arun Kumar Manna Supra. In the instant writ petition is liable to meet the same fate. It has been submitted that the order passed in the case of Arun Kumar Manna Supra has been carried in appeal, and the same is pending before the Honorable Division Bench. The fact of the pendency of the appeal will not make any difference in the present case. The argument now, Lordship, then ultimately it has been held, the writ application has been set aside. Now, Lordship, against that, the petitioners prefer an appeal. Lordship, kindly take the trouble.
Yes.
Page 3. Having heard, has the Lordship got it?
Yes.
Having heard the parties and considering the materials placed, although learned counsel for the appellants strongly presses that the matter be heard on the basis of the documents compiled in the form of a paper book, this court is of the view that the claim of employment which allegedly arose in 1981 cannot be allowed to subsist in the year 2021. The attention of this court is drawn to the fact that with the long passage of time and with the admitted steps taken to secure the rights of the alleged uprooted persons through payment of compensation, consideration of employment by local advisory committee, as present prayer for employment cannot survive at the end of 40 years. Before parting with the discussions, it also needs to be mentioned that the writ petition itself has been filed in 2010, that is nearly 29 years after the Labour Department circular dated such and such. In my case, Lordship, 27 years, according to my learned friend's client. The principle is well recognized in law that delay defeats equity, which, if at all, the appellants claim to belong in their favor. Thus, although the appellants also furnish a copy of the order dated such and such in mat such and such, it is submitted is an appeal on the similar issue where the Honorable Division Bench was pleased to grant liberty to prepare paper book. This relates to Arun Manna's. To the mind of this court, a period of 7 years has been lapsed since the order passed. Applying its mind on the facts of this case and detailed order of the Honorable Single Bench dated such and such, this court is not persuaded to pass a similar direction for preparation of informal paper book. In this backdrop, it stands dismissed. Now, Lordship, kindly, after 2002 notification, another round of litigation was filed or initiated at the instance of the land losers. Lordship, kindly take the trouble, page 3. Because our contentions has been reiterated here, I will not trouble your Lordship. kindly take the trouble, page 3.
Yes.
Having considered the rival submissions, the mid portion as a lordship court, having considered the rival submissions of the parties and the materials on record, this court finds the name of the petitioner was registered with the State Employment Exchange on December 2016. Here it is 2015. My learned friend's client, page 73. Under exempted category, the relevant employment exchange for recruitment of the petitioner is the State Employment Exchange and not the National Employment Exchange. The petitioner has to wait her turn to be considered for employment. The petitioner also has not been able to show that there are several communications made on her behalf to the concerned respondents praying for consideration of her case for appointment from 2011 to 4th November 2022. The petitioner has made a representation by way of demand of justice only on such and such 11 years after the land loser certificate was issued in her favor. Even though the petitioner has instructed her advocate that several communications have been made to the office of the respondent authorities on behalf of the petitioner, this court finds no such communications on record. Lordship, pausing for a moment, no communication has been filed in this writ application also that they have made a representation to the government employment exchange. The court also finds the memorandum dated such and such and the January dated such and such have been superseded by notification dated such and such here in above. The case of the petitioner has to be considered in terms of the Labor Department's notification number such and such dated August 21, 2002. Pursuant to the said notifications, the petitioner's name has already been registered with the Employment Exchange. The petitioner has to wait her turn for the recruitment. No legal right for the petitioner has been violated by the respondent number 2 or 4 or the authority concerned. In the light, the writ petition has been dismissed. Against that, an appeal has been preferred. The Honorable Appellate Bench did not interfere with the order passed. Only the order of dismissal has been transformed into disposed of. Lordship, kindly take the trouble, page 2. All the submissions have been recorded. I am not troubling your Lordship. The 7 item, column 7, Lordship.
Yes.
The appellant is aggrieved by the use of the word dismissed in the writ petition as it might stand a wrong signal to the authority concerned. Although we are of the view that irrespective of the word dismissed, the right of the appellant is accrued, is required to be considered under the notification dated such and such. We dispose of this appeal by replacing the word dismissed with disposed of and with a further direction upon the Director of Employment Exchange to forward her name to the appropriate authorities for appointment of the appellant under exempted category from the waitlisted candidate as and when her turn comes in terms of the notification. It appears that the land has been requisitioned in the year 2003-2004 and the land loser certificate issued on 21st February 2011 in favor of the husband of the petitioner. The writ petitioner registered her name in the National Employment Notification Exchange on 21st February 2011 and the State Employment Exchange on December 12, 2010. The learned counsel for the petitioner apprehends that the candidature of a writ petitioner may reject on the age bar. We are of the view, in the event the name of the petitioner is recommended by the employment exchange under under exempted category, age bar should not stand in the way for considering her application for employment to the suitable post in the organization to whom her name may be forwarded. So I cannot do anything. The name has to be forwarded. Now, since the matter is pending almost 8 years before the employment exchange, we would direct the said authority to immediately look into the matter and forward the name immediately when her turn comes, as delay may cause difficulty for her to get employment with regard to the age bar. So no direction has been given to the respondent company before your lordship to give employment. Now, lordship, kindly take the trouble. On the last occasion, your lordship was kind enough to direct me. Lordship, kindly take the trouble to consider 101 of the writ petition. There is a reference of a case, Kanchan Rouge, where my learned friend's client wanted to be a party. That was rejected. That's why this new case has come. In that matter, series of communication has been given by the government, which shows that as and when the authority requisitioned or intimates about the employment, they are sending the name. Even your lordship kindly considered in respect of this honorable court in 2024, the employment exchange did it. In the same manner, it relates to the honorable court. So far as EC categories are concerned, after 2002 notification, in terms of 1999 Act, no one can act beyond it in respect of EC category. And government has placed a number of communications to Coach Bihar, to Jalpaiguri, to Darjeeling, to Mohestola, everywhere, wherever the vacancies arose, there is a publication, and on that publication, on the basis of that publication, the requisitioning body is approaching the employment exchange, and they are sending the name. Okay. These are my respectful submissions. So my learned friends' clients' rights have been accrued under 1999 Act. That is to be done in terms of that notification. And no direction can be given which my learned friends' client wants before your lordship can be passed. These are my respectful submissions.
Yes. My lord, as far as the petitioner number 1 is concerned, my lord, the learned friend has relied on
Let him finish.
I am for the state, my lord, state acquisition the land and handed over to the requiring body, honor, and compensation made to all the land acquired, all the persons.
Yes.
And petitioner at the time of land acquisition, they are minor. Minor has no right to any right to eligibility as a appointment as a land loser. According to policy formed by the government by a notification 2002, all land loser, their name may be registered as a exempted category to the employment exchange. And according to vacancy declared by the government, their name may be forwarded. The employment exchange the act, it is specifically mentioned, their all vacancy will be declared under section 4 of this. Kindly see, all vacancy will be declared, and on the section 4, left hand, kindly see.
Yes.
All vacancy declared according to requisition sent to the employment exchange. Employment exchange will name may be forwarded to the authority concerned for appointment of the other notes, it is specifically, my lord, it is clear regarding the notes of section 4, my lord. My lord, my submission, my lord, petitioner is not eligible for appointment
Okay.
such a land loser category, my lord. My lord, this is my learned friend elaborately stated everything. My lord, the several judgment also mentioned. My lord, this is my submission.
My lord, as far as the submission regarding the age of the petitioner is concerned, my lord, as my learned friend has relied on the certificate, Madhyamik certificate, my lord, in that notification of 1998, my lord, it has been stated unequivocally, it has been stated that one member from the family of the land loser is supposed to be given employment. At that point of time, my lord, today, presently, my lord, obviously, my lord, the father of the petitioner who received the compensation, obviously, he has, my lord, crossed the age of 60. Now, my lord, at this point of time, he will not be eligible for, my lord, receiving employment. So, my lord, the
No, now stage, now whether it is binding upon the concerned department, concerned authority to give appointment,
in terms of
this
the,
is
my
the
lord,
issue.
in
Now your prayer is that you seek some direction upon respondent number 2, 3 and 5 to take immediate steps for giving appointment. By the virtue of the decision of this court, whether they have any bindings to give appointment.
my lord, by the subsequent notification of the year 2002,
Yes.
the previous notification was not, my lord, completely terminated. The notification, my lord, as I have pointed out on the last occasion, my lord, the previous notification, my lord, was only for the specific purpose of the people belonging to the land losers under the Bokreshwar thermal power project. Subsequent notification, my lord, placed the people belonging to
No,
the
you
land
are saying that the notification of 2008.
2002.
No, 2002 is the notification, and previously you are saying 96 and 98.
98. That notification of 96 and 98 has not been, my lord, cancelled by the subsequent notification of the year 2002.
All notification has been cancelled by 2002.
As I pointed out, my lord, on the last occasion, my lord, the subsequent notification is of the labor department, and the previous notification was of the power department. And my lord, by the judgment, my lord, that my learned friend has relied on,
Yes.
that judgment, my lord, by that judgment, the scope of the, my lord, notification cannot be expanded. The scope of the notification is only restricted to the labor department. Whereas, my lord, the earlier notification of the year 1998, that was by the power department. Now, my lord, what I am saying is that, my lord, they have, according to the subsequent notification of the year 2002, my lord, they maintain a list. And in my case, my lord, certificate of employment exchange has already been issued. Now, my lord, I am only concerned with an employment. Now, my lord, in terms of the 98 notification, one member from the land loser's family was supposed to be given employment. Now, my lord, it is not mentioned as to, my lord, who is supposed to receive employment, whether the person who has received compensation is to receive employment or some other member of the family. Any member of the family, any one member of the family is supposed to receive employment. Now, my lord, certificate has already been issued to the petitioners. Now, my lord, it is, my lord, the duty upon them, my lord, to follow that list and to give employment. Now, my lord, I cannot wait indefinitely, my lord, for, my lord, receiving employment. They have to at least specify a time limit within which, my lord, they can, my lord, give me employment,
Right.
or at least give some type of, my lord, assurance that within this period you will be receiving employment. But, my lord, I cannot wait indefinitely. They are saying that right has accrued in my favor. They are not denying that. So when they are saying the right has accrued in my favor, my lord, so, my lord, once the right has accrued, my lord, my lord, I have to be given the opportunity to exercise that right. I cannot, my lord, wait indefinitely, my lord, to, my lord, exercise that right. Already, my lord, certificate has been issued in favor of the petitioner. Now, my lord, since that notification, 27 years have passed, and, my lord, already, my lord, the people, the members of the family who has received the compensation, my lord, they are already ineligible to receive the, my lord, employment. That is why, my lord, the petitioner, being the son of the, my lord, person who received the compensation, has applied and employment exchange certificate has been issued in his favor.
Now you say, what about the status of 98 notification? What is your submission?
In my respectful submission, my lord,
It
Nine-
is for 2 years.
in terms of this notification, I pointed before your lordship on the last occasion, my lord. They have already, my lord, prepared a list of candidates. As lordship kindly comes to one for another time, my lord, kindly comes to page number 71. Note sheet, your lordship will see report on the selection proceedings held on 3/3/2001 for subscription of the land losers at Bokkeshwar Thermal Power Plant. My lord, in terms of this, my lord, meeting that was committee that was formed, the committee has recommended the names of the candidates, and that is at page number 71. So, my lord, if my lord, this particular, my lord, by the subsequent act of 1999, if my lord, this earlier notification was completely, my lord, cancelled, in that case, my lord, why did they, my lord, prepare the list in the year 2002? Nowhere, my lord, it is mentioned in this, my lord, note sheet that, my lord, because of the subsequent act, the, my lord, earlier notification stands cancelled. They have prepared the list, and subsequently in the year 2002, my lord, the
No,
land
2001, what is the age of Narayan Chaudhary?
Narayan Chaudhary, lordship kindly.
2001, Lordship.
Yes.
2001.
His name is featuring in the list, my lord.
And Lordship kindly consider what is the date. Thereafter the notification has come. 3rd March 2001. And I believe in this 71, page 71, my learned client's name, Gauranga Shah, is not there.
My lord, my submission is that in terms of the 98 notification, they have taken steps to select and prepare the name of the candidates who are eligible to receive the, my lord, employment. So, my lord, they have taken steps. It is not that, my lord, by the subsequent act of 1999, the earlier notification stands cancelled. Because already, my lord, in the year 2001, as I have pointed out before your lordship, they have taken steps. And subsequently, in the notification of 2002, they have placed those people who belong to the land users under the exempted category.
But the law is well settled. Even the select listed candidates doesn't have any right to get employed. The law is well settled inside the judiciary. And can an executive order override the statutory provision? May I put a question to myself? Right has been, I never deny that right has not been accrued. Right has been accrued under 99 Act by virtue of the notification of 21st August 2002. So that has to be followed. This is the consistent view of this honorable court. And 96, 99, or 98, no averment has been made.
Yes.
That nobody has got any employment. No averment has been made. God knows what has happened when he was of 2 years and 4 years of age.
Well, they are not denying that a right has been accrued in favor of the petitioner.
Very. That's all.
Well, I am praying for, my lord, at least, my lord, let them produce the list of those candidates, my lord, who are supposed to, my lord, give employment in terms of the seniority.
I don't have any list.
Lordship, kindly, my lord, let me take some instruction in this matter, my lord.
Again, why instruction?
With regard to, my lord, whether the petitioner,
Today I am supposed to dispose of this matter.
my lord, kindly give me, my lord, some time, my lord, to take instruction, because, my lord, with regard to whether the petitioner are interested to get employment under the exempted category, or whether, my lord, they are following the
No,
98.
whether you just apprise this court whether 98 notification is now existent.
In my
After 2002 notification, how? There are several judgments that it is not now existent.
As I pointed out in the 2002 notification, that was issued by the Labor Department. And it is categorically mentioned in that notification, my lord, it supersedes all the notification of the Labor Department. And whereas the earlier notification was of the Power Department. So, my lord, in my understanding, my lord, how can the subsequent notification that was issued by a different
It was categorized by this court and several judgments.
But, my lord,
That by this judgment all superseded.
but my lord, the subsequent judgment of this honorable court, my lord, that cannot go beyond the notification. My lord, whatever is there in the notification, it is there. By the subsequent judgment, my lord, it cannot be expanded. My lord, let me take instruction in this matter, my lord, with regard to, my lord, what is the, my lord, what the petitioner wants, whether they want employment, my lord. Let me take instruction, my lord. Kindly take up this matter after 1 week, my lord. Let me take some instructions.
What is the deliberation of hearing of this matter? Long, very, you come, okay. I will give a liberty to take instruction. Very well. No issue. Please take down. Argument on behalf of the party is concluded. The petitioner seeks accommodation to reply on to argue on reply. No. Argument on behalf of the parties concludes. On behalf of the petitioner, the respondent number 4 to 6 as well as the state respondent concludes. Full stop. Petitioner seeks accommodation to argue the matter on in reply. According the matter be adjourned today. List the matter on next Thursday. Under the same heading.
One thing, Lordship, I see subject to Lordship kind approval. Can it be item number 1, the way it is being
24, the same heading. Under the same list. Same heading, same position.
Same position.
Same position.
I'm declared.
Yes. Next. Yes.
At page 19, I have placed before your lordship, kindly turn the vacancy notice notified on 8th of January 2024.
Yes.
The first box, your lordship, kindly see Gram Panchayat, Ranighat. Have you lordship got my? This vacancy has been notified in Gram Panchayat area. For that, I am realizing. So it is a vacancy at Gram Panchayat area. Now kindly turn the page.
Yes.
Page 20. Clause part 2(8) eligibility criteria. Have you also got my top?
Yes.
But Roman 4 requirement of size of godown and shop for running ration shop for Panchayat area. I have shown to your lordship, this is a Panchayat area. It must have the space of minimum 300 square foot along with covered space of 100 square foot adjacent to the godown to be used for office purpose for weighing and epo's operation. Total number of compartments for shop and godown should not exceed 3 and should be adjacent connected to each other. If the godown and shop are accommodation in the same compartment, the can shall be 300 square foot. Then, problem number C. Minimum height of the godown should be 2.43 meter, meaning thereby 8 feet. E. Baranda with shade to accommodate lips with 5 people. These are the eligibility criteria. Then kindly turn to my lord. I have categorically stated in my petition at para 15, page 6, that there is no shade so far the baranda is concerned, so far the private respondent is concerned. At para 15, page 6, I shall show to your lordship. Then turn the page 21. Part 4. Then the applicant must submit the following. Client take note of must submit the following copies of original supporting documents along with application in form A1. But your lordship knows in inventory tender matter there are two types of options. One is essential, another is non-essential. When there is a must or shall, it must be an essential one. Kindly come to my lord A. 10A in case of ownership. Then small b, document showing character of land. Have you also got my lord?
Yes.
Dokan, commercial, vastu. If record of right is not produced. So it should be dokan, commercial or vastu in respect of the ownership and also in respect of others, my lord. I am not going to show that. Then kindly, my lord, come the next page. Part 5. Other terms and conditions. 11 Roman 4. Any suppression of fact or information or incorporating providing of wrong information in the application form or attached document will be considered a good and justifiable reason for disqualification for a candidate or rejection of application and taking appropriate legal action also. But these are the terms and conditions. Then you should turn the page, next page 23. I have submitted my application on 3rd of March, which will appear from page 23, 3rd March 2024. You can kindly turn my page 26. So for my eligibility criteria, first bank document, page 26. Turn the page, page 27, 3rd March, top, kindly see 1st March, then 3rd March, more than 50,000. Have you also got my lord?
Yes.
More than 50,000. Next page, PAN card I have annexed, page 28, page 29, schedule caste certificate. My lord, your lordship knows it carries 2 marks. Page 29, schedule caste. Then page 32. Sketch map. Kindly take note of my lord, this page 32. The left hand side, first picture, then the box. Go down, shopcom office, veranda. Have you also got my lord?
Yes.
Kindly turn the next side, right hand side, after second, third column. Area of land. The box.
Yes.
Area of construction, plinth so and so, 49 square meter, 504 square feet. Shopcom go down. Requirement 400. For plinth area, veranda, 176.89 square feet. Total area, 681 square foot. Requirement is 400. Height of the building, 3.9 meter. Height of the from my lord, ground level to my lord, plinth level. Kindly see my lord, 0.6 meter. Now your lordship, kindly next page, the lease deed. This is the registered lease deed executed on 28 February 2024. I have shown to your lordship. I have submitted my application on 3rd March. So much prior to that, my lord, lease deed has been executed. Kindly come to my lord, page my lord 35. It has been given to me. Kindly see second paragraph. Bleach Grohita Titiyo Pakko Bhishoday Podikari. Well, this is the petitioner before lordship.
Yes.
Then Shorto Shomo October so 20 years. Requirement is 4 years. You will also kindly turn to page 21. It will appear, my lord. Registered lease date is required for 4 years. I have 20 years. Then, my lord, kindly next page. Topshil Bonnito Sampotti, my lord, it has been recorded as Budam.
Yes.
Then kindly come to page 43. Medical certificate I have annexed, page 44. Last 3 lines is clinically healthy and fit for normal duty. That is page 44. The next page, my lord. Affidavit as per the prescription, paragraph 3, 4, and 5. No family member or myself is a dealer. Post of any panchayat, gram panchayat that I have also affirmed as in terms of the advertisement. Then kindly turn, my lord, page 47. I have been called for, an inquiry has been conducted. Kindly see the date. 17th May 2024. Well, this is very important. Inquiry has been conducted. Now, what happened, my lord? Next page, kindly see. This is my case, page 48. After more than 7 months, in accordance with the advice of the additional district magistrate, pausing for a moment, not the district level sub-selection committee. Additional district magistrate personal capacity issued advised the authority dated so and so enclosed in the note sheet to conduct inquiry against 2 fair price shop, re-inquiry. Vacancies under so and so, so and so, so and so, scheduled on 16th December. This is all after more than 7 months. Kindly see the committee. Name of the officer, Ruben Guerra, Subdivision of Food and Supplies. Sri Sanjeev Ghosh, West Bengal Civil Service Executive, Deputy Magistrate, Deputy Collector, Mekhliganj, and Subdivisional Officer. Well, this has not banned by the Fair Price Shop Selection Committee. ATM in his personal capacity. Framed a committee, including my lord, 1 magistrate of Deputy Collector. I shall show to your lordship from the notification who can be a member of that committee. But kindly take note once again, my lord, the additional district magistrate himself, as personal capacity, advise the authority concerned, which he cannot do. Then, my lord, inquiry has been conducted. second inquiry. Then, my lord, kindly turn the page 49. I have categorically stated on that day, forcefully a signature has been obtained by those inspecting personnel. Then kindly turn the page 49. Hearing. After second inquiry, body inquiry, on 6th February 2025. That is also after 2 months from the date of inquiry. Then, my lord, rejection letter, page 50. Vishwa Adhikari on 3rd March 2024, my application has been rejected. At page 50. Now, your lordship, kindly come to page 51. The land documents record of rights of the private respondent Bolen Bormon. This is the private respondent number 6. Bolen Bormon 1003. Jomi Seni Bashbagan. This is subsequent to inquiry, second inquiry, and hearing also. Now, your lordship, 2-3 pages I shall show to you paragraphs. Your lordship, kindly come to para 10 to 16 at page 567. The case made out by me, just 2-3 paragraphs I shall read before your lordship, page 5. Paragraph 10 I am reading.
Yes.
The petitioner, upon such information of rejection, went to the office of the subdivisional controller food and supplies to know the reason of such rejection, but the subdivisional food and supplies failed to disclose any reason, rather informed that the respondent number 6 has been selected. Upon having information of selection of the respondent number 6, the petitioner made inquiry and came to know that that would be respondent number 6 has constructed his godown at the land being Dag number so and so, Khotian number so and so, Moda so and so, which is classified as Bashbagan, and collected the document wherefrom it would appear that the Dag number so and so is the Bashbagan. Next page, my lord. That I have annexed, I have shown to your lordship. The petitioner, being suitable in all respect against the vacancy of question, should have been favorably considered by the respondent, but the respondent authorities have deliberately ignored. There is no provision under 2013 controller for re-inquiry at the district or district level so and so, but in the instant case, re-inquiry was held at the direct dictate of the said committee, not by the committee, but the personal authority. Classification of the land is local, commercial, pass-through, whereupon the godown is to be constructed by any applicant in a mandatory criteria for granting appointment. In this case, this is Bashbagan. Then paragraph 15, the respondent number 6 is not qualified in response to one other criteria, that is shed for persons in queue which is not available. This is the mandatory condition. Paragraph 16. While granting state land, this is the so and so, I have made out this case manner. Now, your lordship, kindly see the circular. The circular says the committee. Kindly see, this is 31st May, and kindly turn the page 22nd May 2023. And vacancy has been notified, my lord, 8th of August 2024. So in our case, this circular is applicable. Vacancy notified on 8th of January 2024. This is 22nd of May 2023 amendment. Kindly, my lord, turn the page number 2. I have shown to your lordship that there is a marking system. Serial number B, clause 2 says, my lord, schedule cast 4 marks. Have your lordship got it, my lord? Then page 4 straight away, my lord. The committee. Before that, my lord, page 4, last column, whether the shop-come godown has a baranda with shed to accommodate at least 5 people. Yes, 5 marks, no 0 marks. I have categorically stated in my description there is no shed, so for the proposed shop-come godown of the private respondent is concerned. Then turn the page, my lord. Box, then 1 line, 2nd line. The sentence starts, the concerned subdivisional. Have you lordship got, my lord?
Page 5.
My lord. Kindly take note, my lord. The concerned subdivisional food and supply RO shall submit his report to the concerned district controller food and supply or deputy director of rationing within the stipulated period after completing the inquiry. Before sending the report, my lord, this is very important. The DDP and SDR through the district magistrate, the district controller food and supply DDR shall place the matter before the district level fair price shop home selection committee constituted for the purpose of comprising of the following officials except of Kolkata and so on. So far district is concerned, name of the officers. Additional district magistrate himself of the district controller and sub-divisional controller. I have shown to your lordship additional district magistrate without forming any committee in terms of this. He advised the committee to take re-inquiry with some officials who does not come within the purview of district level food committee. Then, my lord, there will form the DLS transfer. Each member of the district level fair price shop selection committee value the applicant scale 0 to 25. Then 5. District level fair price shop selection committee shall make its recommendation of the most suitable candidate on the so and so. In case no applicant was found so and so. Well, there is no permission for re-inquiry. That too by an individual person who is the additional district magistrate. This is not the decision of the committee. Additional district magistrate advised, kindly take note of that second notice. To form, he has himself formed a committee and directed to re-inquiry. It is not the decision, collective decision of the district level fair price shop selection committee. You will have to kindly take note of that notice at page 48. Once again. This vitiates the entire selection process. I got the highest marks, I have categorically stated in the first inquiry. That may not be found positive by the additional district magistrate, but he cannot do anything. The committee is the empowered. Page 48, kindly read, my lord. In accordance with the advice of additional district magistrate general dated 20th November 2024, enclosed in the note sheet, he made a note sheet forming a committee, excluding the district controller himself, and incorporating the name of one ex-deputy magistrate. He does not come within the purview of food and supplies. This is total erroneous. Vitiates the entire selection process. Where is the provision for re-inquiry? And that too by an individual concerned, who is the additional district magistrate, not by the committee. District level fair price shop selection committee, my lord, it consists additional district magistrate, district controller, and the sub-divisional controller. In this case, he formed a committee, he kept sub-divisional controller, then a magistrate and the chief inspector, according to his whims and choice. And this report has ultimately been considered, nullifying the first report, where I have been selected the most suitable candidate. Total vitiates the entire proceedings. There is no such permission to re-inquiry by the committee event. In this case, the individual has instructed the sub-divisional controller to conduct an inquiry, and he formed a committee by taking outsider, a deputy magistrate. Why the first report has not been accepted? No disclosure. And that is after 6 months. There is a time, but your lordship knows within 15 days, hearing should be given place. The inquiry, there is no such permission. Not by even by the directorate. Well, I shall rely upon only one judgment on this ground. That this is reported, my lord, 2020, volume 17, Supreme Court cases. Page 7.
Order the difficulty is that this is unjustified.
This is a case of Ramba. I have to divide. Possibly in the movie.
I can understand that today Mr. Sahara is pressing for the interim order.
Yes.
That's
One.
very well.
Kindly come to my lord, para 7, page 5.
Their judgment is documented.
Para 7. Para
Yes.
page 5. At this stage, it is important to analyze the tender condition. As was correctly pointed out by Mr. Kassan, clause 2.15 set out fair and above makes it clear that it is only at a pre-tender stage that's answerable. So what happened, my lord, in this case? The security deposit must be given for 40 months. He has given it for 5 months. Then, my lord, subclause is also important because all tenders are cautioned by the clause that tenders containing any deviation from the contractual terms and conditions, specifications or other requirements will be rejected or non-responsive. Then, my lord, paragraph, next page, all the judgments have been relied on. Page, my lord, kindly turn to my lord, page, my lord, 7. The BSN Joshi has been relied on. This is an important judgment, paragraph 15. BSN Joshi has also been relied on. Then, my lord, the ultimate paragraph 16. Page 16 at page 8, paragraph 16. It is clear even on a reading of this judgment that that words used in the tender document cannot be ignored or treated as redundant or spurious, they must be given meaning and their necessary significance. Given the fact that in the present case, an essential tender condition which had to be strictly complied with was not so complied with, the appellant would have to power to condone lack and such strict compliance. Any such condonation as has been done in the present case would amount to perversity in the understanding of the appreciation of the terms and tender conditions which must be interfered with by the constitutional court. But mandate is that there should be land should be like dokan, commercial or bus. Admittedly, his shop is like bus cover. There is no shade, specific government. Today I am paying your lordship since my landed fund is appearing for limited period, pair G or H ballot, kindly come. This is my interim pair. Pair GH at page 16. I am paying for pair H for limited period so that my landed fund can take instruction also. At page 16, an interim order of injunction restraining the respondent authorities from issuing license or status quo, whatever your lordship shoots, for a limited period. At least I have made out a prima facie case. All my documents eligibility, second inquiry is not permissible under the law. You cannot take the law in your own hand. You are ADM, mayor, one of the member of the committee. Individually, you cannot take any decision. Whether district controller is chosen to you or not, that's not your business.
Okay.
Instead of district controller, he brought your deputy collector. These are my submissions.
Yes,
Okay,
Mr. Sengupta.
Well, the thing is that, as I understand from the exhaustive argument of Mr. Saharai, today he is pressing for the interim order. Now, so far his locus is concerned, he is an unsuccessful candidate challenging the proceedings. More particularly, Milord, the re-inquiry which has been held by the ADM in accordance with the law or not. Now, Milord, Lordship know far better than I do, Milord. The decision of the same can be challenged. The process cannot be challenged. Milord, I have shown to your lordship, Milord, in one of the the matter, Milord, the re-inquiry power is vested to the authority. Now, I'm not going into the merit of the case because I require to file the affidavit to that extent. What I am on today, Milord, the license and the offer letter has already been issued to the Milord, the private respondent.
Okay.
Now, I shall tell you the date, Milord. Private respondent, namely Bolen Bolmon, offer letter issued on 2nd April 2025, license issued on the 7th April 2025.
Okay.
Now, keeping in the mind, since the Milord, the offer letter and the model license has already been issued, Milord, without hearing him, Milord, I believe, Milord, in fact, Milord, I have not received the entire instruction. I was under the impression that I have to confine to that issue, whether the license or offer letter issued to him. Now, I have taken that part of instruction because it is coming from the North Bengal. So, it's a little difficult. I have to file, Milord, and I have to answer all the queries forwarded by Mr. Shahara in that event. Milord, there is no scope of the interim order. In fact, Milord, the tagging or otherwise, it takes some time. Lordship may pass an order, abide by the result of this writ petition. Since he has challenged the same, Lordship has, in the many cases, Lordship has held, if the Milord, the selection procedure which we have been adopted, found palpably wrong or arbitrary, in that event, Lordship have a power to issue the mandamus by cancelling the same. Let the affidavit be filed in the meantime, Milord, and let that be, Milord, abide by the result of the writ petition. That is my submission. Because I am not empowered with the entire things. I can show to your lordship at least 3 judgments. One is the Tata Cellular. Second is of, Milord, the Dayanand Maran case.
Yes.
Third is of, Milord, our High Court judgment, Akash Construction, where Mr. Shahara is also appeared. There are judgments, Milord. So I am not going into the merit of the case. I am only confining to the extent of the scope of the interim orders. We have already given the offer letter and the license.
So far reply is concerned, my lord, I have not passed through any judgment which says even if statute does not gives any permission, a statutory authority can do whatever he like. Your lordship, note this is a settled principle that a general public can do whatever he like in accordance with the law.
Authority
But so
cannot.
far the authority is concerned, it's a settled principle, unless power is invested to him, not a single power can be enjoyed by the statutory authority.
Well,
I
I
have
will
shown
come
to your
back.
lordship that KDM has already formed a committee beyond the scope of statute. Today, your lordship goes through hundreds of matters. Division bench paragraph 10, not to dealing any ration card. Your lordship has also passed the order, and this matter is being heard by the division bench.
No, that's a
So
different.
I am praying default no. So far the part of interim order is concerned, license has been granted not to issue any order for linking of ration cards or tagging of ration cards.
But in
For
that,
7 days, for 7, my lord, it says, my lord, it will not take, it will take much time.
no, not much time. I said it will take little time, but I am not seeking for any judicial order. I am not inviting that.
Keeping it on Wednesday, pass an order,
And
maintaining status quo as on today, or not to tag any ration cards or
Well, it-
make any allotment.
Would your lordship pass that order without hearing Millet the successful candidate? That's the question.
Yes, we shall give another notice also, and he has already served, my lord, that has received, my lord.
Millet, heaven will not fall within the
Not fall, it's
exactly.
allotment.
I am also saying so.
Heaven
Heaven
will
will
not
not
fall.
fall.
Heaven will
Heaven will not fall. If Mr. Sarai can wait for such a long time, he can wait.
I have not waited. Immediately
has
I'm
to.
doing this. Kindly see,
Very well. Okay, okay.
My lord, my
I
lord.
have-
my lord.
Please take down. Petitioner applied for FPS license in terms of notification issued by the SCFS Megliganj, wide memo number 20 stroke SCF and S stroke MKG stroke 2024 dated 8th of January 2024. Full stop. Petitioner applied for the license by making specific application. His proposed shop cum go down was inspected by the concerned authority on 17th May 2024. Full stop. It is the contention of the petitioner that suddenly by an advice stroke order of additional district magistrate G concerned, the SCFS Megliganj formed a committee for further inquiry over the proposed shop cum go down of the petitioner as well as the private respondent. However, the interview was conducted on 6th of February 2025, whereby thereafter the candidature of the petitioner was rejected. It is the case of the petitioner that the private respondent was selected for the said vacancy, though the private respondent has no eligible criteria as per the vacancy notification. Full stop. It is the firm contention of the petitioner that the proposed shop cum go down of the private respondent was constructed over plot number 103 of Mauja Solmari under district Coach Bihar. The said plot number was recorded as Bans Bagan. Full stop. Bans Bagan হয়েছে 1003 লিখেছো তো plot number 1003 হয়েছে Mr. Sahara has placed the relevant part of the notification wherein it has been mentioned that the character of the proposed land wherein the shop cum go down would be constructed should be within inverted comma, dokan stroke com should be কি বলবো? Go down would be constructed should be within inverted comma, dokan stroke commercial stroke bastu, full stop. The land where the private respondent constructed her go down is Bansbagan. Thus, the private respondent has no eligible criteria to have the license. Mr. Saharai further pointed out that the additional district magistrate cannot form a committee for re-inquiry of the vacancy position after the inquiry has been conducted by the concerned sub-divisional controller, food and supply. He placed the notification dated 22nd May 2023 regarding the evaluation process of application for grant of license of FPS. He also placed the specific portion therein regarding the construction of the district level fair price shop selection committee. Full stop. Mr. Saharai submits that the concerned SCFS under the instruction of additional district magistrate cannot form a committee and reconsider and re-anchor the proposed shop go down of the applicants. The act and action of the concerned SCFS Mekliganj by virtue of memo dated 11th December 2024 is beyond the provisions of the notification. By such, they have exceeded their power. Hence, the decision-making process has been vitiated. Thus, the selection of private respondent required to be set aside. Full stop. Learned counsel, in support of his contention, he cited a decision of Honorable Apex Court in Vidarbha Irrigation Development Corporation and others. Vidarbha Irrigation Development Corporation and others versus Anuj Kumar Agarwal within bracket 2027 SCC page 577 paragraph 16 set of court. Full stop. Mr. Suman Sengupta, learned counsel appearing on behalf of the state authority, on instruction submits that the offer letter was issued, offer letter as well as the license has already been issued in favor of the private respondent. Full stop. Offer letter was issued on 2nd of April 2025 and the license has already been granted on 7th of April 2025. Full stop. Mr. Sengupta frankly submits that the tagging of ration card has not been made in respect of the new vacancy in favor of the private respondent, and it shall take necessary time to do the same. Full stop. He submits that as the selection has already been done, so no interim order can be passed without hearing the person with the packet private respondent in whose favor the right has already been created.
When even me, without giving the exhaustive reply.
Mr. Sengupta further argued that the point raised by the writ petitioner before this court can very well be demonstrated and countered by way of a affidavit by the state. Full stop.
Any
He seeks for time to file affidavit against the writ petition. Having heard the learned counsel for the parties, considering the situations herein, it appears that affidavit of service filed on behalf of the petitioner shows that the service upon private respondent, no, the service of the writ petition upon private respondent is not complete. Full stop. Mr. Saharai pressed her to pass an interim order as interim order in this matter. Full stop. It appears that in the writ petition, the prima facie challenge is the act and action of the authority regarding their justification to issue memo dated 11/12/2024 for re-inquiry of the vacancy. Re-inquiry of the new vacancies. Full stop. It has also been alleged in the writ petition that the land wherein the private respondent has prepared the proposed shopcom, constructed the proposed shopcom go down is a Bans Bagan. Full stop. Fact suggests that offer letter as well as the license has already been issued in favor of the private respondent. At this juncture, it appears to be justified to hold that without hearing the private respondent, no interim order can be passed. However, I make it clear that the petitioner has prima facie established that the memo dated 11th of December 2024 is a document and action of the authority adheres to the notification and provisions of law. However, it is quite additional district magistrate. No, it is not clear to this court that whether additional district magistrate has acted on his personal behalf or acted as a member of district fair price shop selection committee. However, the action alleged prima facie appears to me not in conformity with the provisions of law. Under the above observation, I think it would be justified to hold that as the petitioner has demonstrated a prima facie case, so all action of the authority since this day shall be abide by the result of the writ petition. Full stop. I make it clear that this order, no, full stop. Let the matter appear in the list again on appear in the, again before the appropriate bench.
Go to circuit bench.
7 days.
circuit bench এ পাঠিয়ে দিচ্ছে না?
So, on 23rd of April 2025, course the petitioner is directed to serve the copy of order upon the private respondent as well as the state authority.
May I pray liberty, my lord, to pay for injunction on that day application in presence of the minority.
Okay, petitioner is at liberty to renew his prayer in presence of all parties.
The maintainability of the writ petition.
Okay, the maintainability of the writ petition kept open.
কোনো affidavit এর ভিতরে শুধু ওইখানে
File will be transferred to the
File to party them.
এটাই মুশকিল হয়ে যাবে কেন বলো তো? এরপর এবার আমি আর অ্যাপিয়ার করতে পারবো না। হ্যাঁ তাই তো আমি তার করতে পারবো না। হ্যাঁ
Ali, let the matter appear in the list
I'm
before the
grateful to
appropriate bench. ঠিক আছে? Appropriate bench having determination. And ওটা চলবে উঠে। Next.
I'm grateful.
Yes, thank you.
এটা কবে থাকবে বললাম আমার 23 তারিখ।
Well, this is a case where the
বুঝলেন
petitioner purchased 66 decimals of land from the
No, where is the respondent authority?
they filed the abuse opposition, we filed the reply, everything is
Everything is there.
yes, my
Pleadings complete. What is the matter?
everything is complete.
Very.
But there, I'm well, what happened in this matter? What lawsuit will find my love from the registered deed, and then it is mutated in favor of my client. So can you come to page 23? 23. My middle plot number 115. 115 reference है 115 dark number 115 page 23 except P2. Come to middle portion
Plot number
115 115 115 Shali 3.23 decimal 3 acres 23 decimal. My area is 0.66 66 decimal. I purchased and mutated. Thereafter, what happened? Lawsuit comes.
when you purchased?
Well,
When you purchased?
I'll be as the delays. I purchased 2009.
How you purchase a acquired land? It was already acquired.
According to them, it is there. I will show whether it is.
You
acquired.
purchased the land in the year 2009
Yes. Yes.
from the owner, namely Kishore Mohan Mandal.
Yes. Kishore Kumar Mondal.
Kishore Kumar Mandal.
Yes. Father is Pure Mondal. No, man, lawsuit can come to the affidavit in opposition. But they are saying it is acquisition property for the purpose of constructing road. And that's why it is changed in favor of the superintendent engineer PW. That's the next page 24. That is the subject of how it has been done. Now, we also can come to their opposition.
Report in the form of affidavit.
Yes. My report of opposition. Now, I also will find.
Yes.
And it comes to the last paragraph. They have said, the second paragraph, letter the Kolimuddin Sardar, my client, have purchased 66 decimals of land out of 3.23 acres of suit land 150. That is the plot. Kishore Kumar Sardar, 2009. And it is found recorded in the favor of the superintendent. But subsequently it was changed. Now, in the light of the above fact, it appears that the suit was on 18/9/1963. followed by notification suspension Act 2 of 1948. Award was declared 66. Now, according to them, it is plot is acquired 1966 and compensation has also been paid. So I have got no right to that. Now, and we come to page 6. Page 6
Page 6 of what?
of their review. This is page 6. How it is managed. You will also find paragraph 2. Entire CS plot, that is 69, that is plot, and part of CS plot. Second, this line 99, plot number 99. Puja, this is my claim. But kindly come to page 7 and number. Terrestrial survey, it is there now. There is survey, plots in part, logically, plot in, not that 3.6, 23 decisions, all has been application. There is 99. Then you will also find. Why I am pointing out 99? These are the plot number, page 9. Second part, 99. This is by 150. CS plot 99 changed to 150. But I am showing 150. I have anything, the RS record of it. Original plot is 99. Now the CS, now RS is 150, LR is 250. That's well. The first knowledge about that, after RS balance is plot is going in, quotient may be changed, but plot is. Now you also will find their next document is K. CS plot number, and we have said part of 115. You can see the page 10 portion. CS plot 115 part. In the second line. Now, Lordship, kindly come to award. Then, page 12. Lordship, kindly get it page 12.
Yes.
Now, what are the 5, 6. Deonath Mohammed. 26.
Yes.
Entire land, 1 acre. That's kindly 1 acre. What is the area of the total area of the land? 3.23. I have got no objection. 1 acre they have taken, they have already constructed the road. It is admitted. I show from the map, and it's from in my reply. They have already taken up, they have completed their work. You will also kindly have a look to my reply. It is their document, it's not my document. They have paid 1 acre has been acquisition and paid them. I have nothing to say about it. Now, but you can see my annexure. Only annexure I have given. Notify RSC. That portion of the RSC.
Yes, got it.
But it's there, I mean, that's called
What is this?
RSC.
Artist record.
Record.
This
Shall annex.
annex page,
Annex
page,
is the enlarged form.
page.
Page, this page. And the only English said on the last part, last thing. My reply.
Your reply.
My last page, back portion. Only one answer. And you look at the enlarged part, you look at
I can read it. I can read it. No,
and
you read it.
page location on the top.
Yes.
99 CS 115. And here you also will find there is a small mallard, small mallard scale. That is part. You also will find part and mark it. And you also will find here they have acquisition Act of 1948 out of 323, 1 acre has been taken. Road has rasta complete. Road has not been complete. They have taken it. So they have got no connection with the other part. They have not yet been acquisition.
No, what it was written? What it was written? Jomir Shreni Sali.
Sorry,
Yes. Then
sorry.
LA acquisition
Yes.
11/81.
That is the case number.
Dong.
That is the case
Superintending engineer. Superintending engineer.
number. You will find take one. That Sally Act. You will find one very small bit. Even their compensation part.
No.
It's
No,
quite clear.
no, you just read it. The entire land was acquired.
No, only one
No, record shows that the entire.
one acre. Basically, act. This is my mark. You can see. Other part is not marked. Only a part has been taken. 1 acre. And it is admitted from the record itself. Record they have given from their acquisition part. Their acquisition part, their compensation part, they are clearly mentioned. 115 for 1 acre. That is page 12. I am not disputing that. 1 acre they have covered only 1059. And they also mentioned 973 is the value. 973. Can they claim, my lord? I am asking a simple question to myself. My lord, when the acquisition is 1 acre, I have purchased 60, total area is 3.23. 1 acre minus 1 acre. I am not that part. I am not on that part. Out of 2.23, I have purchased 66. Now they are giving this, that road has already been completed.
So what is your prayer here?
My prayer is, this record is illegal. Because my land, which recording has been changed, I also know knowledge about that. Never serve any notice that this is.
No, your prayer, you claiming compensation.
No, question of compensation, if it is acquisition, then question of compensation.
So what is your stand?
My stand is
Whether your
if it is acquisition, then that part has not been paid.
so what is the present record of right?
There is record in my favor, but they have changed now. After my record of right, they changed against the change.
So your submission is that
The
that
record
your
is illegal.
purchase land was
Has not
never
been
acquired.
Not
Never acquired.
No.
So what is your prayer?
My prayer is
You
that should
want
be
the land to be
restored by-
separated, or
no.
then
There is better than that. This is my prayer is restored my record of rights.
then you have not made any prayer like that.
I have made because that point of time I did not get all this. But because if I
And you know the law that this court has no right to.
Lordship can mold.
No.
Yes,
This court,
my lord has the power.
there are specific
that is
provisions in the WBLR Act and Estate Acquisition Act to make a prayer before the authority for correction of record of right, not before the High Court. I cannot mold.
But
You have the authority to apply for correction of record of right under the specific provisions.
my logical platform. A reason or the nature of mandamus. That is the respondent 3 to cancel and or remove the name of the respondent number 4 from the LR record of right. If the land is not acquisition as per law. So this is not acquisition as per law. I am placing of prayer.
Very well. There is the appropriate authority, for correction of record of rights.
But that is the PLR.
Yes, appropriate authority is there. You have to make a specific application. I can leave you to go to the appropriate authority.
But
If you
if
if you succeed, you can get an order.
My lordship can consider this. Appropriate authority will act, certainly will act as per order of the court, not on his own, because they are claiming this is already acquisition. That is the confusion.
Yes.
So they force, because the authority is the government.
No, you banked upon all the
Yes.
documents issued by the government authority.
But-
You banked upon. So you have the document, you place,
Yes, but the
you
document have
approach the
shown-
authority.
but from the on the face of the record.
Okay, you approach the authority. Yes.
On the face of the.
I have nothing to say, my lord, if that is your lordship. Send the matter to the BLR and BLR will
Yes.
conduct, my lord, everything.
Yes.
And acha baba, darao. As because, my lord, my case is the entire land was acquired. But my learned friend, as my learned
He
friend,
can justify
and my
that.
lord, for a long time, my lord, he is, my lord, taking here and there. So, my lord, your lordship can send the matter to the respective BLRO, and BLRO will pass the order in accordance with law after hearing both the parties, that is
all concerned.
A and land depot,
Yes, yes.
that is asked, my lord.
My lord, this
And
should
এক মিনিট দাঁড়াও না, তুমি তো অনেকক্ষণ বললে।
be- No,
My lord, after affording reasonable opportunity of the parties, and my lord, they also keep their papers, and I must file the entire documents and pass the reason order
Very well.
within.
one thing.
না 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 না,
My friends, my lord,
তোমার ফেভারই তো
they
বললাম।
have given the জানি না, no, okay. So একটা, my lord, the documents which they have annexed.
My lord, every
One-
document he can file there.
Yes, yes.
So whatever may be that,
No, no,
I
no.
give
That-
him
that
or
direction,
yes,
I'm
ma'am.
asking
No,
you
no, no,
that
no.
direction.
Every, আমি তো সবই
My
করলাম.
lord,
Every document you can find that.
I told-
Yes, you can use those documents. I shall give you allowance.
Yes, ma'am.
Okay, very well.
I have no any objection, my lord. I
Their
supplied him
document-
that document. He
Here
must-
document you are banking upon.
Yes, my lord.
He's my one of the best friends.
Very well. Please take down. Petitioner purchase a land bearing RS plot number 115, measuring 66 decimal out of total 3 acre 23 decimal from one Kishore Kumar Mandal, son of Priyonath Mandal, by a registered deed of sale dated 10th of February 1975. It is the case of the petition that the respondent authority has erroneously acquired the entire land. No, respondent authority has not acquired the entire land, but has acquired only 1 acre of the land for the purpose of construction of road. Construction of road.
I denied that, my lord. Our case is, my lord, entire.
He submits that the present LRROR was recorded erroneously. Thus, he approached this court with a prayer that if the entire land was acquired, he is required to be given the required compensation. He also made a additional prayer that respondent authority may be directed to correct the recording of the land. Full stop. By virtue of the leave of this court, the state respondent has filed the report in the form of affidavit coupled with a status report. Full stop. The status report of the state disclosed as follows. বলে এই একদম পুরোটা করে দাও on verification.
And the recording of land in favor of this one number 4.
It is the firm contention of the respondent authority that prior to the purchase of the land, the said land was acquired and the compensation has already been paid to the erstwhile owner of the land, namely Priyonath Mondol and Hemantonath Mondol. The incident, it is the further contention of the respondent authority that the writ petitioner is a post-acquisition purchaser and is not eligible for any compensation as per provisions of law. Full stop. Learned counsel for the petitioner pointed out several documents annexed by the state respondent with their report. By the said documents pertaining to the proceeding of land acquisition of the relevant land, including the RS plot number 115, including CS plot number.
Yes, 99 RS.
Yes, including the CS plot number 99 corresponding to RS plot number 115. Full stop. He placed the relevant portion of the proceeding of acquisition and submits that only portion of CS plot number 99 within bracket corresponding to RS plot number 115 bracket close was acquired by the same process. Full stop. He also placed the relevant RSROR wherefrom it appears that the CS plot number appears that only 1 acre of land of CS plot number 99 corresponding RS plot number 115 was required for the construction of roads. Having heard the learned counsel for the parties and considering the documents, including the papers regarding proceeding of the alleged land acquisition case. It appears to me that the petitioner has justifiably demonstrated the fact that a portion of plot being CS plot number 99 within bracket corresponding plot number 115 corresponding RS plot number 115 was acquired. Full stop. The prayer was made before this court for correction of record of rights. There are sufficiently no, there are a specific authority for correction of record of rights. Full stop. The concerned block land and land reforms officer is the authority to pass a necessary order for correction of record of rights. At this juncture, I think it justified to relegate the matter before the concerned block land and land reforms officer to consider the grievances of the petitioner for correction of record of rights. Full stop. Under the above observation, the instant writ petition is disposed of with a direction to the petitioner to approach the concerned block land and land reforms officer for his desired relief for correction of record of rights. Full stop. I make it clear that the writ petitioner shall approach the concerned block land and land reforms officer by making a specific representation along with the necessary documents as which he wants to rely. Full stop. I also make it clear that the petitioner may use the documents placed by the concerned state authority before this court for the betterment of the decision by the land reforms officer by the concerned BLN LRO. Full stop. The concerned BLN LRO shall dispose of the representation of the petitioner after giving reasonable opportunity of being heard to the petitioner as well as the concerned respondent authority within 8 weeks from the date of receiving of such representation. Full stop. The decision of the authority shall be intimated to the petitioners within 2 weeks thereafter. Under the above,
My lord, that is the provision of appeal. There is a provision of appeal. So, my lord, your lordship would not.
I am not passing any such.
My lord, your lordship was pleased to direct to give the copy. My lord, that is the provision of appeal of section 54 of the Act minute. Provision. My lord, there is a provision of taking the certified copy of the same. So, my lord, I pray not to give direct the PLRO to give him a copy. He must take the certified copy of the order. If
No.
the order is, my lord, go against him, my lord, he must file appeal according to the section 54 of that.
No, which order? Which order? I
That
cannot
order
follow you.
Which was passed, my lord. Your lordship was pleased to direct him to.
This is a case of acquisition.
No acquisition.
If there were no acquisition.
No. I direct you to approach the BLLRO for correction of record of rights.
Yes, my lord.
If the correction of record of rights, there is a order. So there is
goes
a
against him,
specific
my lord.
provisions of the appeal and everything is there.
Yes, my lord.
That is
Everything is there. They will proceed.
So, my lord, I pray, my lord. So, my lord, I pray that you will get the certified copy of the order.
Which order?
That is the order passed by the PLRO.
Oh, that is the separate
the
process. They will do it otherwise.
No. Yes, my lord.
So you are saying that the copy of the order within 2 weeks of the decision, that is you saying that there is a provision of getting certified copy.
Yes, my lord.
This you want to do.
Yes, my lord.
Okay.
I shall hand over the certified copy of the order within 2 weeks. From the
Certified
date of
copy.
the. Yes, my lord.
Okay. কি বলো হ্যাঁ কি বলো
তাই বলা হচ্ছে একটু দাঁড়াও না এত কথা বলো
passing of this order from the date of receiving of the representation. Full stop. The concerned authority decision of the authority shall be intimated to the petitioner through a certified copy Within 2 weeks from the date of passing of the,
Yes, my lord.
that you want.
Yes, my lord.
Okay.
Shall no, I shall apply and we shall get it.
Of
After application.
Within 2 weeks thereafter. Okay. I make it clear that this court has not entered into the merit of this matter. The concerned BL and LRO shall dispose of the representation according to the law, without being
According to the provision of law.
according to the provisions of the law, without being influenced by the any observation of this court.
Yes, ma'am.
My lord, the observation means my lord also
No, no, no.
this part. I'm saying.
Now.
I have recorded your submissions.
Recorded all the submission and Lordship found it from the record itself found that this is not acquisition that part. So
All-
Lordship says that Lordship will not, they should not take into consideration of the anything Lordship has
Now
not
look, I have seen the part of the documents like that.
Yes.
So
Yes,
this is the domain of the BL and LRO.
yes,
He
yes.
shall deal with the matter, no issue.
Yes, madam.
I have given you the liberty to place the documents. No
Yes,
issue. You can, okay.
Take care of.
Writ petition disposed of.
Yes, madam.
Next. Okay, I have some fixed matter. Yes, this is item number. Your matter you have concluded.
madam.
Yes.
1, 2, 3, I have concluded.
And-
starts from 4.
Item number
That
4.
is the only matter.
Yes, what is your matter?
My lord,
You are the
I'm the administrative group 3 administrative staff. My
group D.
3 administrative staff.
সব রেখে দেবেন একসঙ্গে কি ছিল ওটা বলো? কাগজ দিন, সারা কাগজ দিন। এতগুলো কি হবে একটা দিলেই? দিন আইটেম নাম্বারটা দিন, আইটেমটা দিন। আইটেম নাম্বার 4. Yes,
My lord, the issue or the facts are absolutely identical to item number 1, 2, 3. So I'm
you
not
are the group D staffs.
group 3 administrative staff. We are non-academic.
Yes,
My lord, first, my lord, I will draw my lord's attention to the orders which we have impugned in this writ petition. My lord, kindly first take note of page 1 to 5.
1,
1 to 5, my. It is a cert.
1 to 5.
Yes, ma'am, of the writ petition.
Yes. This is the circular.
My lord, it is a circular which reads dated 4th December 2019. My lord, it reads as in furtherance to this office circular dated such and subsequent letter issued to individual staff based on this office circular. In consequence of the letter received from DST bearing number such and such, the undersigned is instructed to inform all non-academic staff, both administrative and technical, that though the competent authority of both institute is continuing with the payment of salary pension as per 7 CPC, till date, excess payment made, if any, to the non-academic staff, including pensioners, due to continuation of the 7 CPC of both institute will be recovered from this salary pension subsequently. My lord, this may be termed as a order of recovery. My lord, this has to be read with page 1 to 7. Why I say this has to be read with page 1 to 7? Because in that order itself, there was a portion regarding recovery of the amount which has been paid. My lord, my first line of argument will be on the point of recovery.
Whether they have recovered
Whether
anything,
they have the power to recover or not.
whether they have recovered anything,
No.
not recovered yet.
In case of 1 to 3
In
recovery.
my case, my two of the matters, there's two CAN applications pending where recovery has been affected from the gratuity.
Okay, petition, can applications are
CAN
there?
applications were pending since main writ petition was heard. I had not pressed for the CAN application. Two CAN application, pensionary dues deducted, entire recovery made.
Okay,
That is in respect of 1 to 3.
so you have challenged the memo of recovery.
My lord, memo of recovery, which my lord will find 125, page 125. This has to read with 127 also, because in this office order, there is also that provision or that decision to recover.
Yes.
My lord, I will only point out to the relevant portion. My lord, kindly take note of 4th paragraph.
Fourth paragraph of what?
Page 127. This is an office order dated
Okay,
5th May 2020.
okay.
My lord, why I am relying upon these two documents at first? Because these are on the point of recovery. My lord, may I read? This refixation of pay and allowance are subject to further verification by audit. Any excess amount paid due to incorrect fixation of pay and allowances are recoverable from the concerned employee, and in case of any short payment made inadvertently due to incorrect fixation of pay and allowance will be paid to the concerned employee by the institute. So, my lord, are recoverable. My lord,
Yes.
now what is the settled proposition in this regard? My lord has seen the judgment of Rafiq Masih. Last
Yes.
occasion, my lord has seen. My lord, I will depend upon only one judgment. My lord, one judgment, that is the judgment of Thomas Daniel. My lord, I will be relying upon the relevant paragraphs only. My lord, first kindly take note of judgment.
Thomas Daniel.
Thomas Daniel, my lord, it has been reported in 2022 SCC Online SC 536.
Yes.
My lord, first kindly take note of paragraph 9, which my lord will find at page 2.
Yeah.
My lord, may I read? This court, in a catena of decisions, has consistently held that if the excess amount was not paid on account of any misrepresentation or fraud of the employee, or if that excess payment was made by the employer by applying a wrong principle for calculating the pay allowances, or on the basis of a particular interpretation of rule order which is subsequently found to be erroneous, such excess payment of emoluments or allowances are not recoverable. This relief against the recovery is granted not because of any right of the employees, but in equity, exercising judicial discretion to provide relief to the employees from the hardship that will be caused if the recovery is ordered. This court has further held that if in a given case it is proved that employee had knowledge that the payment received was in excess of what was due or wrongly paid, or in cases where error is detected or corrected within a short time of wrong payment, the matter being in the realm of judicial discretion, the court may, on the facts and circumstances of any particular case, order for recovery of amount paid in excess. My lord, after that, kindly take note of paragraph 13, wherein Rafiq Masih was quoted. My lord, in my case, I believe my lord has taken that paragraph 18 has been quoted in, this will be paragraph 13, para 18 of Rafiq Masih has been quoted. I believe, my lord, our cases fall under, my lord, may I just indicate? It is not possible to postulate all situations of hardship which would have governed employees on the issue of recovery where payments have been mistakenly made by the employer in excess of their entitlement. Stop. Be that as it may, based on the following decisions referred to above, we may as a ready reference summarize the following three situations where recoveries by the employers would be impermissible in law. Recovery from employees belonging to class 3 or class 4 service. My lord, this is one applicable via group 3 administrative staff. So we belong in most likely to group class 3 service. My lord, number 3,
recovery from the employees where when the excess payment has been made for a period of excess of 5 years before the order of recovery is issued. My lord, admittedly, in this case, this promotion order was given on 2000 in the year 2008, given effective from 25/12/2005.
Yes.
And this has been continuously paid, as my lord has already seen, till 2019. So therefore, almost 14 years.
Yes.
5. In any other case where the court arrives at the conclusion that the recovery, if made from the employee, would be iniquitous or harsh or arbitrary to such an extent as would far outweigh the equitable balance of the employer's right to recover. My lord, so admittedly, it is not the case of the Bose Institute or the Union of India that there was a misrepresentation or fraud which has induced them to grant us this promotion. Therefore, my lord, as on today, as it stands, the decision which they arrived, which they communicated to us on 4th December 2019, that circular has to go. It is against the settled proposition of law as it stands today.
Yes.
And also, my lord, part of the circular of the office order dated 5th May 2020 regarding the recovery portion.
Yes.
My lord, now I will draw my lord's attention to other orders which have been impugned. My lord, kindly take note of page 132. My lord, it is a communication which has been addressed by one B.K. Shukla, who is the head scientist and head. My lord, may I just indicate? As you may be aware, as per the explained such and such, it has been classified that where the categories of employees whose pattern of annual structure, that is pay scale and allowance and conditions of service, are not similar to those of the central government employees, a separate group of officers in respect of which of each of the autonomous body may be constituted in the respective ministry department. It is found that in some of the autonomous institutions of DST, the non-technical administrative staff are enjoying better service conditions and promotional avenues. As advised by our finance, you are kindly requested to submit an undertaking duly signed by the registrar of the institute that only vacancy-based promotion is being granted to its non-technical administrative staff. It has been further suggested that to withhold the 7 CPC benefits to these non-technical administrative employees till the group of officers recommend the case where vacancy-based promotions are not followed. In view of the above, you are kindly requested to take necessary follow-up action as suggested by your partners. My lord, there is another challenge which is at 135. This is the decision of the ministry.
135.
My lord, it is dated communication, rather it is a communication come decision, page 135, dated 16th October 2019.
Yes,
by the ministry.
I have seen that. No issue.
My lord has seen that.
Yes.
After 11 years, a decision has been declared to be null and void. My lord, first issue is whether it was incumbent upon the Bose Institute or the ministry to grant the officers or the employees who will be affected by an adverse decision to grant them an opportunity to explain themselves. My lord, in this regard, my lord, it is an admitted fact that before this decision to curtail or to revert to the position which these employees were holding in the year 2005 was never communicated to them. There was no opportunity to give an explanation. What was communicated to us was a decision. Now, whether such conduct or action is permissible or not. Not the first judgment I will be relying upon in this regard is on the point of civil consequence as well as the necessity of natural justice. My lord, may I just hand over? My lord, it is one reported in 1980, volume 4 SCC 379, SL Kapoor. My lord, kindly first take note, paragraph 7. My lord, will find that at page 385. My lord, undoubtedly, all these actions which are impugned herein are administrative actions. Now, what are the criteria which has to be followed in respect of an administrative action has been disclosed herein. My lord, may I just read?
Yes.
The old distinction between a judicial act and an administrative act has withered away, and we have now liberated from the cysticism incantation of administrative action. Now, from the time of the decision of this court in state of Orissa versus Dr. Ms. Vinapani Devi, even an administrative order involves civil consequences must be made consistently with the rules of natural justice. What are civil consequences? The question was posed and answered by this court in Mahendra Singh Gill, speaking for the, my lord, Krishna Iyer J, speaking for the Constitution bench. My lord, now it has been. What is civil consequence? Let us ask ourselves by passing verbal booby traps. Civil consequences undoubtedly cover infraction of not merely property or personal rights, but of civil liberties, material deprivations, and non-pecuniary damages. In its comprehensive connotation, everything that affects a citizen in his civil rights inflicts a civil consequence. My lord, undoubtedly, this reversion and reduction of pay scale undoubtedly attracts our civil life. My lord, thereafter, my lord, kindly thereafter, my lord, the other were discussed. My lord, now kindly take note of paragraph 8. My lord, may I read? My lord, this is the first case regarding what is violation of natural justice and fair. In Smith versus Secretary of State for Home Affairs, Lord Denning, MR, observed, the speeches in Reach versus Baldwin shows that an administrative body may, in proper case, be bound to give a person who is affected by their decision an opportunity of making representation. It all depends on whether he has some right or interest, or I would add some legitimate expectation. My lord, kindly mark these two words, interest, or I would add some legitimate expectations, of which it would not be fair to deprive him. It was held that in that case that a foreign alien had no right to enter the country except by leave, but if he was given leave to come for a limited period and his permit was sought to be revoked before the expiry of the time limit, he ought to be given an opportunity of making representation, for he had a legitimate expectation of being allowed to stay for the permitted time. Now, Lord, how this is to be equated in our given case? My Lord, has not required to see the repetition again. My Lord, I am just reading out the relevant communication. My Lord, kindly take, my Lord, page 124 is that communication. It is dated 25th February 2019.
Yes.
My Lord, it has been addressed to one Pravi Kumar Haldar. My Lord, what does it read? This is reference to the office circular number such and such. The undersigned is directed to inform you that promotion given by institute during your service tenure will be reviewed as per the guidelines mentioned in the said circular. That's it. Nothing more, nothing less. What I have been told, I believe this is the nature of circular which communication which has been addressed to all. Will be reviewed. No, not a single whisper has been granted to that individual whose life will be affected by any adverse decision, that kindly tell us that this will be the decision to the maximum. I'm saying, like in disciplinary proceeding, a show cause is given before a proposed penalty is imposed. So now they have decided, like, now let us consider this proposed penalty to be reduction in pay scale and reversion to the old post. I am entitled to give my justification as to whether whether this proposed punishment or penalty is justified in the eye of law or not.
Okay.
At the end of the day, my lord, Bose Institute is an autonomous body. The governing council of Bose Institute decide all the issues regarding the services of its employees. I am not concerned what an outsider like DST does or directs. My employer is Bose Institute. It was incumbent upon my employer to give me an opportunity to substantiate that the decision which you arrived at consciously was correct. Like an example, my lord, now SEBI, State Bank of India. SEBI decides something against State Bank of India. As a consequence, State Bank decides to stop the salary of its employee. Is it permissible? Answer is no. It is an autonomous authority. Maybe the major shareholder is the government of State Bank of India. But it has this term, autonomous, has wide implications, my lord. Otherwise, if my situation was such that, my lord, this writ petition would not have been maintainable before this honorable court. I would have been a civil employee, and my remedy would have been before the Central Administrative Tribunal. At one hand, you are saying that I am an autonomous institution, my governing council decides the fate or decides the everything of my employees. At another hand, you are leaving aside the benefit or the welcoming of the employees at the instance of an outsider. My lord, it is nobody's case, not a single document has been produced before this. My lord, rightly or wrongly, all these disputes started at the time of implementation of 7 CPC. I may be wrong, subject to correction. Before that, there was 6 CPC. There was 5th CPC. Was there no objection? Admittedly, as on today, there was no objection. So what was the intervening circumstances which prompted you to arrive at such a drastic steps is absent today.
Okay. Anything?
Well, there are judgments I will be relying upon. Only judgments I will be relying upon. That's it. Nothing more.
Very good.
Should I finish this judgment? But there are other paragraphs. My lord, thereafter, kindly take note of paragraph 11. My lord, this is at page 388. 388.
Yes.
My lord, this was a submission which was on behalf from the bar. Another submission of the learned Attorney General was that Section 238 also contemplated emergent situations where swift action might be necessary to avoid disaster. That if such situations, if the demands of natural justice were to be made, the very object of the permissions would be frustrated. My lord, this will be the stand, or this is the stand of the Bose Institute. Emergent situation to avoid disaster, we have to take that steps. It is difficult to visualize the sudden and calamitous situations gloomingly foreboded by the learned Attorney General, where there would not be enough breathing time to observe natural justice, at least in a rudimentary way. A municipal committee under the Punjab Municipal Act is a public body consisting of both officials and non-officials, and one cannot imagine anything momentous being done in a matter of minutes and seconds. And natural justice may always be tailored to the situation. Minimum natural justice, the barest notice, and the littlest opportunity is in the shortest time measure. My lord, after that, kindly take note of paragraph 16. My lord, it is at page 391.
Yes.
My lord, may I just read once? Thus, on consideration of the entire material placed before us, we not have any doubt that the New Delhi Municipal Committee was never put on notice of any action protest to be taken under section such and such, and no opportunity was given to the municipal committee to explain any fact or circumstances on the basis of that action was proposed. If there was any correspondence between the New Delhi Municipal Committee and any other authority about the subject matter of any of the allegation, if information was given and gathered, it was for entirely different purposes. In our view, the requirements of natural justice are met only if opportunity to represent is given in view of proposed action. The demands of natural justice are not met even if the very person proceeded against has furnished the information on which the action is based, if it is furnished in a casual way or for some other purpose. We do not suggest that the opportunity need to be a double opportunity. That is, one opportunity of the factual allegations and one on the proposed penalty. Both may be rolled into one, but the person proceeded against must know that he is being required to meet the allegation which might lead to a certain action being taken against him. If that is made known, the requirements are met. We disagree with the findings of the High Court that the committee had the opportunity to meet the allegations contained in the order of supersessions. My lord, paragraph 17 should also be taken note of. And lastly, my lord, paragraph 24. I'm just reading once paragraph 24 at page 394.
Yes.
The matter has also been treated as an application of the general principle that justice should not only be done, but should be seen to be done. Jackson's natural justice contains a very interesting discussion of this subject. He says the distinction between justice being done and being seen to be done has been emphasized in many cases. My lord can go through this rest of the paragraph. Now, 395, my lord. I will only rely upon the judgment and how that judgment is relevant in our case. That will be my basis of submissions, my lord.
Okay, you come on and reply them. Let them finish first. Okay.
My lord, may I just indicate the judgments? May I hand over a copy of the judgments because only this judgment I believe they have not referred to. I believe I will have a discussion with my friend. If they have not referred to there are two other judgments on 2 points. One will be on promissory estoppel and one will be on legitimate expectation. That's so. My lord, 3 judgments in total, and this I will hardly take, my lord, this 15 minutes. No, I copy the my lord, I am handing over the copies of those judgments which I am going to rely upon today itself to the parties. My lord, I will just rely upon the judgments and then thereafter they can start.
No, next Wednesday.
Thursday.
Next Thursday.
Thursday.
Next Thursday, from the beginning, I can start this matter.
Yes, ma'am. It will be, they can start their.
They are ready. Thursday.
I will be giving the judgments. I will be giving the judgments, copy of the judgments today itself.
Yes, Alam, you have to start.
Yes, Lordship. Actually, I was thinking of a week because I'll have to assimilate both the arguments. So,
what you want? Let them finish first.
let them finish first, and then the next following Thursday.
Come on, then 12:30.
Then yes, let them come at
12:30
12:30,
next Thursday.
and then the following Thursday I'll start.
Okay. Right. Please take down argument on behalf of the petitioner within bracket WPA. Argument on behalf of the petitioner within bracket WPA 6140 of 2020. Continues. Place the matter on 20, 24th at 12:30.
12:30. Then the next day
at 12:30, 24th of April 2025 at 12:30.
The judgments have been handed,
Yes.
all the judgments.
Separate orders of all the matters. Separate orders. Arjun sir.
সবগুলো আলাদা করে না
My lord, I am appealing for the petitioner, my lord. My lord, last occasion, my lord, I moved this application, but I failed to produce the original application annexure, my lord. This is the original application and along with the Xerox copy, my lord. Kindly see, all everything is given, my lord.
What is this? The
Uh, everything, my lord, I fulfilled their criteria, my lord. Everything, my lord.
what is your case?
My lord, what happened, my lord? The vacancy was uh, stated, my lord, that the vacancy notification issued, my lord, subdivisional controller, food and supply, Siliguri, where this application from individual self-group registered cooperative society for filing a vacancy for fair price of dealership. So, my lord, I filed the form, my lord, for fair price dealership in the year 2014, my lord. But, my lord, they did not any give any notice, anything, my lord. So, my lord, I give a letter to the representative.
You take the mic, I cannot hear you. You take the mic properly.
Thereafter, so, my lord, 18th to February 2025, my lord, I am giving the letter said notification that the wide vacancy notification such and such, my lord, the where under invited application for MR dealership of village such and such, that pursuant to aforesaid vacancy notification, I fulfill the requisite criteria for such dealership, and as such, I duly submitted application in prescribed format with requisite fee. Something is. So, my lord, I have stated everything, my lord, in my representation. So, my humble submission will consider the representation that.
No. The vacancy you have applied in the year 2014.
But, my lord, the vacancy is, my lord, vacant, my lord. That is why, my lord, I again this letter I have given that the on 18th February 2025, my lord, annexure.
No, I understand. You have submitted one application in the year 2014.
Yes, my lord. Thereafter, this vacancy was, my lord.
Why late? Why 10 years gap?
Because, my lord, there are some COVID, nothing has been.
No.
given, my lord.
COVID is only 2 years.
So, my lord.
Why late 10 years?
But, my lord, the dealership is vacant, my lord, my lord. That is why, my lord, I have such send the representation.
In your application, you have stated that you have the 50,000. You have only deposit 50,000 in your bank.
No, thereafter, my lord, thereafter 5 lakhs, thereafter, my lord, 50,000. At present, now, lord, 50,000, my lord.
At the time of making application,
50,000.
No, 5 lakh.
5 lakhs.
5 lakh is required to be there.
Yes, I am ready to pay. Now, my lord, at present, now, lord,
But you are not ready to pay.
Yes.
The condition is that you must have a bank account of rupees 5 lakh
Yes.
for running the business.
Hmm.
But you don't have such capacity.
Yes, yes, I have stated, my lord. I have stated.
What you have stated? Where is the document?
Because kindly see my list.
Your document shows that on 9th of February 2016, you have a bank account of 4 lakh only. You have to demonstrate your case properly. In the year 2014,
now thereafter, in the year 2016, my lord, I stated. There now my at present, my lord, I have 14 lakhs, my lord. So not.
No, that is not the eligible criteria. Eligible criteria at the date of application, you must have a 5 lakh in your bank account.
No, first, my lord, 50,000. First, thereafter, my lord, 5 lakhs. Kindly see, my lord. At that time, my lord, that is why I am stated 50,000, my lord, in my application.
You read page 25, your application. You read page 25. I know that. This is the eligible criteria in the advertisement.
Yes, yes, that is the 10th October 2014, my lord.
Yes.
The size of the gold, everything is, my lord, completed, my lord. But regarding the
you read 1. Point number 1.
Yes, 5 lakhs and working capacity are reflected on the day of application. But now at present, my lord, 5,000.
No, at present is not required. Requirement is that at the time of application, you must have a bank account that is working capital to be 5 lakh. Whether do you have any document to show that at the time of making application you have 5 lakh in your bank? You don't have any document.
There is no such documents. But my lord, at present, my lord, the
At present is not required. At present your working capital is nothing.
No. Yes.
At present your working capital may be 5 crore, but that is not the requirement criteria. Criteria is that at the day you file the application for vacancy, you must have a working capital of 5 lakh. That is the criteria. You have to fulfill that.
My lord, but my lord, vacancy still now, my lord.
No.
Not fulfilled, my lord. That is why, my lord, my lord, kindly see, my lord, one thing, similar application, my lord, I moved before the Honorable Justice Vivek Chaudhary, my lord, was then, my lord. Kindly see, this is the same order, my lord. Kindly, similar application, my lord. Kindly see.
No, these are clause 20 of WPDS maintenance and control order. That is other issue altogether. Mrs. Goswami, I am dealing with this matter regularly. That's why I know. This is the memo. Whether this memo dated 10th of October 2014, you have fulfilled that memo. The eligible criteria in the vacancy notification is that you must have a working capital of 5 lakh in your bank account at the day of filing application. Not before that, not after that.
No.
And it should be maintained within 1 year. That is the law. That is the notification. That's why they issued that memo that you don't have any bank account. If you any document to show that at the time you have the bank account, you have filed a document showing that you have the 4 lakh, that to the other account.
But my lord, this is the my lord case. But at present, I move this application.
Moreover, you are moving this application after 10 years. After 10 years.
But vacancy
what is
not
the
fulfilled,
justification?
my lord. Vacancy, my lord, vacant now.
No, that is not the requirement. Whether I do
That
not
is
know
why,
whether
my lord, I have come, my lord.
I do not want to know the status of the vacancy. I want your locus.
Yes,
What is your locus?
That I will show these things, my lord.
What is your locus? Show me that you have the document. You have the document. You have the bank account. You have the eligible criteria to get the license. Then I can allow you to pass an order.
Then,
Got
my
an
lord,
order.
this is a Siliguri, my lord. So, my lord, it will take time.
You
my
understand
lord.
the issue?
Yes.
Issue is that at the day of filing your application, that is, you have filed the application on such and such date. On that date, you have a working bank capital of 5 lakh. They ask that this is the requirement. Have you answered their letter? 10th of October 2014.
Yes, I have given my
What
lord.
is your answer? Yes. What you want to submit? Do you have any instruction, or I shall dispose of this matter?
No, my lord, kindly give some time, my lord, because the Siliguri case, my lord, it will take time to
Okay,
come.
you take instruction, you receive your document from your client, and then mention this matter. Please take down. Let the matter go out of the list.
Original
What is the
copy টা
date to
দিয়ে
mention?
দেবেন, হ্যাঁ? Original copy টা একটু দিয়ে দেবেন।
Call the next matter.
কবে হলো date কবে?
Yes. Thank you.
Not the earlier day, I have stated the reasons of rejection of my claim. I was on my claim for common area maintenance charge, and my claim was rejected by the learned arbitrator. What was the reason that I have explained to you, Lord?
Yes.
And I will explain now. I was placing the award before your lordship. Page number 84, my lord.
Yes.
I'll just place the award and then I'll argue it. The provisions entitling the claimant to claim. Let me first
take the mic first.
Let me refresh your life, my lordship, my lord. The claim has been rejected. Basically, my ground is that it is contrary to the terms of agreement. It is contrary to law. It is contrary to evidence. It should not have been rejected.
Yes.
The provision. Now I'm placing the order, award, my lord. The provisions entitling the claimant to claim common area maintenance charges are to be found in clause C2 read with clause E9 of the agreement, which read together makes the sublicensees the respondents to pay the maintenance charges on actual rates charged by the concerned authorities. Concerned authorities contemplated in the agreement was a service company or an agency to be called Facilities Management Agency. Apparently, there had been no such service company or such agency appointed or entrusted with the task of carrying on the work of maintenance. It should be made clear that dispute relates to maintenance of common areas supposed to be carried out by the claimant or carried on by the claimant, as opposed to the day-to-day maintenance of the scheduled premises, which was the responsibility of the respondents. But my liability was to maintain outside and their liability was to maintain inside. Naturally, no bill for maintenance was ever raised with any particularity or in a routine or systematic manner. The claim for maintenance made by the claimant in this reference is somewhat capricious and arbitrary, ignoring the provisions of C2 and E9 referred to above. The claimant sought to support his claim in this regard on the basis of loosely worded phraseology used in clause E10 to the effect that the sublicensee would be liable to pay and clear maintenance charges as may be levied by the licensee Facilities Management Agency on proportionate basis within 7 days on presentation of the bill without demur. Reference on the said clause entitling the claimant as licensee to levy maintenance charges clearly does not contradict or override the clear stipulation of claim maintenance charges as at actual rates be raised by the claimant himself or by an appointed agency. This is just contrary to the earlier sentence, my lord. I have said the question is who will certify what is the common area maintenance charge. My clause E10 says I have a right to raise common area maintenance charges bill, and normally the common area maintenance charges is at cost, my lord. Whatever money is spent on the maintenance, proportionately as per their chargeable area, it is claimed, and we did that. Now there is no question of loosely worded or strongly worded. Whatever it is, I'll come to that point below. The claimant sought to found his claim for maintenance charges with reference to the provisions in his agreement with the railways, being the agreement dated 16th of April 2004, both for the purpose of defining the liability and calculation of the same. In course of argument, reference was made to clause E25 of the claimant's agreement with reference with the respondents, which says, in effect, that the sublicensee were always bound by the terms and conditions contained in the lease agreement between the licensor and the licensee, that is me and railways.
Yes.
Meaning thereby the agreement dated 16th of April 2004 entered into between the railways and the claimant, described therein as licensee and licensor and licensee. On basis of clause 3J in his agreement with the railways, the claimant claimed maintenance charges on the basis referred therein in proportion to the area and occupation of the respondents. I do not consider that clause E25 is wide open to justify such approach, entitling the claimant to claim maintenance charges on the footing ignoring or overriding the clear provisions of C2 and E9. More so, when the respondents were not parties to the claimant's agreement with the railways, nor the said clause was incorporated in the said agreement 30th in their agreement. This is absolutely contrary to the agreement, my lord. I have placed that railway agreement before your lordship on the last day, my lord. The railway agreement has categorically said 10 rupees per square meter to be payable by the sublicensee. And they are the sublicensee, my lord. So roughly 1 rupee per square feet is there. I have to pay to railways, my lord. Then he said it has not been indicated in the agreement.
Yes.
In clause 25, it is very clearly stated, my lord. I have placed before your lordship. It is very clearly stated. Now they said that they were not a party to the agreement between railways and Surana. How can they be a party between me and Surana, between me and a railway? It has been stated. I have given a copy of the agreement to them before execution of the agreement. They were aware of all the terms and conditions. Now take for instance, my lord, demerger agreement. I was not a party. The demerger agreement order has been accepted. But here my agreement with the railway, they say that they were not a party. Normally, my lord, what happens if I take a property on lease and if I sublease, I cannot violate the terms and conditions of the main agreement.
Yes.
I am to rely on that only. And that is the thing here only. True that the claimant did not proceed on that basis, on the basis provisions of clause C2 and E3. Well, C2 is, I have said license fee is exclusive of maintenance charges. And then they say their covenant is there that we will pay you the maintenance charges. E9 says unfettered commitment by them that we will pay you the maintenance charges.
Yes.
But the issue still remains whether the respondents could avoid the liability of maintenance charges made on the basis on any other basis. I find from the letter dated 5th November 2008 that a claim was made by the claimant on the account of CAM at the rate of rupees 150 per square feet. The said figure has been worked out initially on the basis of the claimant's agreement with Railways, referred to above. The said letter dated 5th November 2008, by which PRIL was asked to pay, among other things, CAM charges at the rate of rupees 150 per square feet, calculated up to February 2009 for Puja Mall, recording that the bills had been enclosed. Again, by a letter dated so and so, the claimant drew the attention of the respondents to his letter dated 28th of February 2008, when such bills for license fee and CAM charges up to February 2009 were enclosed. I have regularly sent them the license fee bill and the claim charges bill, and I have disclosed sample bills with them. The only problem was that when I disclosed that letter, by mistake, I did not annex the annexures. During the process of proceedings before the arbitrator asked Mr. Sarana, where is the statement? I submitted that statement. That has also been recorded, and that I have disclosed in my disclosure of documents also.
Yes.
That is page 24 and 25 and disclosure of documents. In course of argument, reference was made to E25 of the claimant's agreement with Railways, which says, in effect, that the sub-licensee respondents were always bound by the terms and conditions contained in the lease agreement between license and licensee, meaning thereby that the agreement dated so and so entered into between Railway and claimant, described therein as licensee. On the basis of clause 3J, in his agreement with the Railways, the claimant claimed maintenance charges on the basis of referred therein in proportion to the area in occupation of the respondents. I do not consider that E25 is wide open to justify such approach, entitling the claimant to claim maintenance charges on the footing ignoring or overriding the set provisions of so and so. More so when the respondents were not party to the claimant's agreement with the Railways, nor the set clause was incorporated in the set agreement. I have explained, my lord. I'm sorry. When this thing was going on, I have disclosed how I have come to rupees 1.50. I have disclosed all the documents. I'll come before that. I'll come before your lordship. I'll place before your lordship. True that the claimant did not proceed on the basis of provisions of C2 and E9, but the issue still remains whether the respondents could avoid the liability of maintenance charges made on that basis. I find from the letter dated 5th November that a claim was made by the claimant on account of CAM at the rate of rupees 150. The said figure had been worked out initially on the basis of the claimant's agreement with the Railways, referred to above. The said letter dated so and so, by which PRIL was asked to pay, amongst other things, CAM charges at the rate of 150. Calculated up to February 2009 for Puja Mall, recording the bills had been enclosed. Again, by a letter dated so and so, the claimant drew the attention of the respondents to his letter dated so and so, when such bills for license fee and CAM charges up to February 2009 were enclosed. Let me place these documents before your lordship. 587 and 341. 341. Volume 3 and 4. 3 and 5. $587. ठीक है volume 3, 4, and 5. Volume 3 will give page 3, 4, 1. Three, four, one. What do you think?
Yes.
Milord 3, this is my letter addressed to the respondents, Milord. We are sending here with a statement showing a sum of rupees 6.96 crores receivable by us as on 10/4/2011 in terms of agreement dated 30th of January 2007. We request you to kindly examine the same at your end and arrange to send us the said amount together with interest in terms of the said agreement. So here, Milord, I am sending this letter on 11th of April. So up to March 2011, the things have been calculated and sent. Now this statement is there. Another disclosure of documents. Page 24 and 25, my lord.
Statement of license fee.
Yeah, in the table, my lord, first is license fee and the second is CAM charges. This statement is annexed with these letters, my lord. This has been sent to them. And in another, the next page 25, where it is up to March 2011.
February 2008 to January 2011.
Rent up to March 2011 and CAM charges also up to March 2011, my lord. In the first column, it is rent. In the second column, it is CAM, my lord.
Yes.
And the total is 696,19,186, which is there in this 341, my lord. 696,19,186. Four A 587.
February.
This is 24 page. Page 24, it is 6 crore 44 lakhs. In the
Yes.
disclosure of documents, 644. The same figure is here, my lord, 6 crore 44 lakh 36,470. So the bills used to be sent like this, my lord. These are the sample bills which we have disclosed in the proceedings, my lord. Volume 3. Volume 3, I think. Volume 3, page 440. Volume 3, my lord, page 440.
Volume 3, 440.
440, my lord. This is an email sent to them, my lord, on 15th of March 2009, my lord.
Yes.
We invite your kind attention to our letter number so-and-so dated 28th of February 2008, enclosing therewith our bill for license fee and camp charges up to February 2009 for Puja Mall, Kharagpur in terms of the agreement rated so-and-so. So these two statements I have shown before your lordship was up to January and up to February, up to March. And here it was sent up to January, up to February, my lord. So this will indicate that we used to send them the bills for camp charges and license fee regularly. And this is an email, my lord, wherein I have claimed my payment also. And there is no denial to this, my lord. We find from our bank that they have not yet received the payment of license fee in respect of our above mentioned bill, although as per agreement, terms of payment of license fee and camp charges is required to be made on or before 10th day of succeeding month. Any delay in receipt of payment of license fee and camp charges beyond the mutually agreed date, that is 10th day of every month, cause acute financial burden and attracts penal interest apart from loss of faith and goodwill by the bank. Another letter 439 also, you can 439, my lord, in the same volume. This is again an email sent to them for payment. We request you to please release the payment of camp charges at the earliest. Necessary clarification as desired by you have been furnished to you to your entire satisfaction. They wanted certain clarification, they were also furnished to them.
Yes.
And it indicated here in this memo. There is no denial to this, my lord. Kindly come to page 342 in the same 441, my lord. Another email for payment. It is requested to please release the payment of camp charges as discussed over telephone at your earliest. We need to make some urgent payment to the contractors and fire department. Your prompt attention and kind cooperation in the matter would be highly appreciated. So these are the emails, my lord, I have shown to your lordship for claiming payment also. I have also shown to your lordship that the bills were regularly sent to them.
Yes.
There are other letters also for payment. Let me place one or two before lordship. 342 in volume 3, my lord. 342.
All of camp charges.
All for camp charges and other charges also, my lord. Because when I used to write, I used to claim everything. They were never making payment in terms of the payment at any point of time, my lord. This is a letter written to them on 26th of September 2011, my lord. Please find attached here with a statement of outstanding license fee, camp charges, electricity charges, and electricity duty on power generated by DG sets. You are requested to make the payment as per annexures attached forthwith to ensure a smooth running of the mall. Needless to mention, you are liable to make payment of license fee by 10th day of every month in terms of the agreement without delay, deduction, demer and abatement, save and except TDS as may be applicable. It is regretted you have defaulted in payment of license fee and other charges. In spite of all the services made available to you as per your demand, your dilatory tactics in making the payment of license fee and other charges in terms of the said agreement are not appreciated. So this is again a demand letter for camp charges, my lord. The next letter is also a reminder to them, sent to them on 21st of October 2011, my lord. 343. Volume 5. Volume 5. Page 690. So by these letters, my lord, I have been able to explain that regular bills were used to be sent to them. At regular intervals, I have chased my payment also, my lord. This is another letter, my lord, sent to them on 5th of September 2009, 688.
Yes.
Kindly come to page 690, my lord. The last but one paragraph. Finally, we once again request you to kindly release the payment of monthly license fee directly to our bank, Union Bank of India, 38 Sen Road, Calcutta. Pay the license fee and CAM charges strictly in terms of the license agreement. Refund the entire amount of deductions made so far. Bear the proportionate cost of bringing power from board. Pay us the entire amount of security deposit collected from the sub-licenses appointed by you and the additional rent receivable from the sub-licenses appointed by you and the additional rent receivable from sub-licenses as committed while obtaining the right to further sub-license.
This is letter dated
This is letter is 5th of November,
5th of September.
September 2009, Mila. I mean, your lordship would find that regularly I used to chase them for payment also. And they never bothered about that, Mila. They never made the payment in accordance with the terms of the contract, Mila.
So they have not paid anything regarding CAM charges.
They have not paid even a single pie, my lord. They have not paid even license fee, my lord. Then another reminder also, your lordship will find at 696, my lord, on the same volume, my lord. This letter was written on 5th of December 2009, my lord. 693, page 693.
Yes.
5th of December 2009. Kindly come to the last page, 696. The same thing, Mila. Finally, we once again request you to kindly release the payment of monthly license fee directly to our bank, Union Bank of India. Pay the license fee, CAM charges strictly in terms of the license agreement. Refund the entire amount of deductions made so far. Bear the proportionate cost of bringing power from the board. Pay the entire amount of security deposit collected from the sub-licenses appointed by you and the additional rent receivable from the sub-licenses as committed while obtaining the right to further sub-license. Your lordship will find that at every stage, I have been reminding to them. I'm just placing paragraph, page 29 of the award, my lord. Page 29. Respondents to letter so and so, such letters. A schedule prepared by the claimant, page 156 CD2, giving details of payments made to various staff and some supporting documents were disclosed. My lord, volume 3, page 435 to 438. Volume 3, my lord.
Page?
Page 435, my lord.
This is the list.
This is the statement which I have produced before the London arbitrator, my lord, that I have paid 24,000 on account of salary, sorry, to my staff, salary to guards 26,000, maintenance of landscaping 16,000, electricity charges 7,500, staff welfare and general charges 10,000 rupees, traveling expenses 2,500, telephone charges 5,000, miscellaneous petty expenses 5,000, all comes to 1,12,000, my lord. And 1 rupee I used to pay, it's about 1,00,000 of rupees I used to pay to railways. So it becomes 2.12 lakhs per month. I was not charging 2.2 lakhs from them. I was charging only 1.50 million. A proportion of this, my lord. 1 rupee was there, my lord. and a small portion of this. So I was charging only 150, I have explained. And my lord, on the next page, your lordship will find 436, the amount of salary which have been paid to Girish Sharma. Then 437, my lord. Again, payment for security personnel. And then 438 is 16,000 rupees, my lord. This 16,000 is for landscaping, my lord. So like this, all the supporting details also I have provided to the learned arbitrator. This is all a monthly on basis, my lord.
Yes.
Now, despite the learned arbitrator states, despite such reference, the bills were not enclosed with the said letter. Now, these bills cannot be annexed with my statement of claim. I mean, when I am raising my CAM bills, I cannot attach all these bills. Your lordship would remember, my lord, I have placed before your lordship the CAM charges which they have raised on me at the rate of ₹12 per month. No documents was there. And unfortunately, those bills were raised by a company which was not in existence at that point of time. No documents were there. And I have placed all these supporting documents to the lordship, to the learned arbitrator, my lord. I have explained how I have arrived at ₹1.50 per square feet per month, my lord. To the best of my ability, I have provided entire details of CAM charges. Respondents contended that no bill for maintenance charges was ever raised and served on them by the claimant. This is most erroneous, my lord. I have placed these documents before the learned arbitrator. The arbitrator has seen all these documents. There is no denial from the respondents, and still it is recorded that respondents contended that no bills for maintenance charges was ever raised and served on the claimant by the claimant. Claimant countered this contention of the respondents by drawing my attention to memorandum of discussions dated 18th of March 2009, annexed to the counter statement of the respondents, wherein at point number 3 it was recorded that no extra CAM to be paid by PRIL. Respondent number 1 for the outside mall area, which PRIL shall maintain. Now, there was a casual discussion in Bombay with me, my lord, and they said, Mr. Surana, henceforth, we will maintain the outside premises. I said, you cannot do that. It is not there in the agreement. You can't do that. So what learned arbitrator says, this according to the claimant made it quite clear that respondents acknowledge their liability to pay CAM and that in fact they did pay CAM till February 2009, though the details were absent as to the rate, amount or manner or assessment. I have very categorically submitted before the learned arbitrator that I have not received even a single pipe. That is the learned arbitrator's assessment. He says that when they say that from tomorrow I will maintain, it means they have paid me up to today. It's not that, my lord. The said remarks is of course open to a further interpretation, again different, implying that the claimant did not maintain the mall maintenance, the mall premises at all till May 2009, but respondents would assume such a responsibility henceforth from March 2009. This is horrendous, my lord. A shopping complex is required to be maintained daily, my lord. And there is no document on record whereby the respondents have claimed that Surana is not maintaining. All circumstances taken together, the claim for common area maintenance is very dubious and contrived. At any rate, in view of omnibus provision contained in Annexure D to the agreement, the claim is not tenable. Annexure D clearly provides that amongst other things, maintenance and upkeep of all utilities in the common area, which are particularly defined in various sub-clauses of Clause C of the said Annexure D, would be the responsibility of the claimant. Whereas the D says it is the responsibility of the sub-licensee. I place that before your lordship. Can I again place it, my lord?
No, I understand.
Now, one thing, my lord, I just wanted to explain here. There are express terms in the contract. I have said my license fee is exclusive of CAM charges. They say their covenant that yes, we will pay you the CAM charges. Then there are express terms in the contract wherein unfettered acceptance that yes, we will pay you CAM charges.
Yes.
Then in clause 10, I have clearly stated the CAM, what will be the CAM charges? It will be decided by the licensee or by the facilities management agency.
Yes.
Now, until facility management agency is created or appointed, it was my responsibility, which I have done. So this is as regards me, Lord, the award is concerned. Now, I have very categorically submitted at the earlier day, my Lord, that this award
Yes.
Now, my submission before your lordship is in respect of the award, Miller. The award has been passed in contravention of terms of the agreement as also in contravention of provisions of law. I have placed those all conditions before your lordship on the other day, Miller. And if an award is passed contrary to my conditions, it is also contrary to law also, Miller. 28(3) of the Act 1996, Miller. The learned arbitrators acted without jurisdiction. Rejection of claim in respect of payment of common area maintenance charges is in contravention of substantive law, thus rendering the award patently illegal as opposed to public policy of India. But let us take a commercial contract into consideration. Let us consider this courtroom, Miller. If it is to be maintained from inside, it has to be a person who is engaged by the honorable institution. As regards the corridor is concerned, it can be sub-licensed to any other agency, Miller. Now, if the courtroom is not maintained, necessary correspondence will be there.
Yes.
If it is not outside maintained, necessary correspondence will be there. No such correspondence, no such letter is on record that I was not maintained.
Or complaint that you have not
No
met.
complaint at all. The patent illegality appearing on the face of the award is such that it not only goes to the root of the matter, it also amounts to erroneous application of law as well. Although the construction of the terms of the contract is primarily for the arbitrator to decide, the construction of the term of the contract arrived at by the learned arbitrator is so unfair and unreasonable that it would not even be termed as possible one. The learned arbitrator did not adopt a judicial approach.
Yes.
The learned arbitrator did not act fairly, reasonably, and did not follow the objective approach. The learned arbitrator acted arbitrarily and whimsically. The learned arbitrator has arrived at a decision by ignoring very material contractual terms, conditions, documents which throw abundant light to arrive at a just and fair decision. The finding is so unreasonable, irrational, and outrageous that it will shock the conscience of the court, and the error would result in monumental miscarriage of justice. The award is not only against the weight of evidence, but is altogether against the evidence itself. The award has been made in conscious violation of pleading and law. The petitioner also seeks to challenge the award as being contrary to the binding judicial principles. Now, my lord, I have placed these documents. They say it is not, London arbitrator say it is not payable. Their counsel has submitted before the arbitrator, it is payable. Contract says it is payable. I'll explain what they have submitted before the landed arbitrator, my lord. Volume 11 and 12. Volume 11, page 1471. One four seven one. This is the arbitral minutes of
25th and
25th and
26th.
26th sitting, my lord, held on 3rd and 4th of December 2013, my lord.
Yes.
Kindly come to page 1471. The bottom portion. The said liability is spelled out. Sorry, the second one, my lord. To pay maintenance charges is another obligation cast on sub-licensee. As mentioned in general terms in clause 3 CD1, without defining in any manner what should it include and to what extent. It is a submission of their respondent, my lord. The said liability is spelled out more particularly in clause C2 and C3, which according to Mr. Saha clearly indicate that the sub-licensee was only obliged to bear proportionately the maintenance charges raised on it on actual basis charged by the concerned authority, which in the context of management maintenance charges would mean service company called Facilities Management Agency, clause E9. So far, the maintenance of the complex, the scheduled property is concerned, the scheduled premises is defined in 3rd schedule of the agreement. The day-to-day maintenance was to be borne by the sub-licensee at its own cost as provided in C3. That is the inside of that, my lord. It would thus be seen, Mr. Saha submits, that two kinds of maintenance charges are contemplated in the agreement. Outer space of the scheduled premises was the responsibility of the appointed agency or by the licensee, while the internal maintenance of the said premises was the responsibility of the sub-licensee without entailing any financial liability on the creditor.
Yes.
In the same, my lord, kindly come to page 1495. This is minutes of 33rd sitting, my lord.
Yes.
Held on 4th of March 2014, indicated at page 1493. I am placing the last paragraph of 1495, my lord. Finally, Mr. Saha takes me through items of claim 33 altogether, appearing at page 23 to 25 of the statement of claim. Mr. Saha says that save and accept claim for license fee and common area maintenance charges, to which elaborate submissions have been made by him, no other items of claim appears to be plausible in the facts and circumstances of the case. It's a clear submission, my lord, that they are liable. It is their liability to pay the CAM charges, my lord.
Yes.
Then kindly come to page 1603 in volume 12, my lord. Volume 12, page 1603.
Yes.
The last paragraph, my lord. Mr. Saha appearing at this stage proceeds to embark on the aspect of determination of the agreement at so and so as the period for which license fee and camp charges could be payable. In other words, in the event the said agreement is not terminated with prior notice and in circumstances referred to in clause 31 of the said agreement, the claimant would be entitled to license fee and camp charges for full 5 years lock-in period. An unconditional confession, my lord.
Yes.
Apart from my conditions, my lord, let me place this section 28(3) of the Act also, my lord. Those 2 lines only. While deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable to the transaction. 28(3), my lord. Can I place it, my lord?
Yes.
While deciding and making an award, the arbitral tribunal shall, in all cases, taking into account the terms of the contract and trade usages applicable to the transaction. My contract is very clear about about camp charges and trade usages also I have explained to your lordship, my lord. Now here in Calcutta, also here in Bombay or in Kharagpur, wherever, my lord, assuming your lordship takes an office, a shop, a showroom, a building, it needs maintenance. That is always apart from the rent payable by the occupier, my lord. And that is on the basis of chargeable area for which the rent is paid, my lord.
Yes.
These are all the commercial deals, my lord. Open commercial deals, applicable everywhere. The learned arbitrator decided the matter strikingly outside his jurisdiction. An award which ignores the express terms of the contract is bad and therefore perverse. The learned arbitrator overstepped the confines of the contract. The learned arbitrator wandered far outside the designated area. The learned arbitrator digressed far away from the allotted task. His error arose not only by misreading or misconstruing or misunderstanding the contract, but by acting in excess of what was agreed by and between the parties. It was an error going to the root of his jurisdiction because he asked himself the wrong question, disregarded the contract, and acted in excess of his authority. The learned arbitrator cannot travel beyond the parameters of the contract. The learned arbitrator acted unreasonably, irrationally, and capriciously and ignored the limits and the clear provisions of the contract. The petitioner submits that it is settled position of law that where a finding is based on no evidence or an arbitral tribunal takes into account something irrelevant to the decision which it arrives at or ignores the vital evidence in arriving at its decision, such a decision would necessarily be perverse. A and B আছে না? A26. This is the judgment delivered by the Honorable Supreme Court of India in Southeast Asia Marine Engineering and Construction Limited versus Oil India Limited.
Yes.
I'm referring to paragraph 7 at page 826, my lord.
Yes.
The High Court held that the interpretation of the terms of the contract by the arbitral tribunal is erroneous and is against the public policy of India. On the scope of judicial review under section 37 of the Arbitration Act, the High Court held that the court had the power to set aside the award as it was passed overlooking the terms and conditions of the contract. Be it 34 or 37, this rule is same. Aggrieved by the same, the appellant has filed this present appeal by way of a special leave petition against the impugned judgment. Paragraph 8, my lord. Learned counsel for the appellant assailing the impugned order contends that A, the High Court has imparted its own personal view as to the intent for inclusion of clause 23 and has set in appeal over the award for the award of the arbitral tribunal. The construction of clause 23 he submitted is a matter of interpretation and has been correctly interpreted by the arbitral tribunal based on the authorities cited before it. B, if two views are possible on a question of law, the High Court cannot substitute one view and deference should be given to the plausible view of the arbitral tribunal. Learned counsel has relied upon a judgment of this court in McDermott to support this contention. C, the question of law decided by the arbitral tribunal is beyond judicial review and thus the High Court could not have interfered with a reasoned award which was neither against the public policy nor patently illegal. 9. In response, the learned counsel for the respondent supporting the findings of the High Court submits that A, the award passed by the arbitral tribunal is contrary to the terms of the contract and essentially rewrites the contract. The arbitral tribunal has to adjudicate the dispute within the four corners of the contract and thus awarding additional reimbursement not contemplated under clause 23 is perverse and patently illegal. Overlooking the terms and conditions of a contract is violative of section 28 of the Arbitration Act and thus the tribunal has exceeded the jurisdiction. This is not a case where the arbitral tribunal accepted one interpretation of the terms of the contract where two interpretations were possible. Findings of the tribunal are perverse and unreasonable as the tribunal did not consider the contract as a whole and failed to follow cardinal principle of interpretation of contract. Now he has relied on annexure D and he forgot all express conditions of the contract. An annexure cannot create a condition of the contract. The conditions of the contract are stipulated in the main contract itself. The arbitral tribunal has rewritten the contract in the guise of interpretation and such interpretation being in conflict with the terms of the contract is in conflict with the public policy of India. I am placing paragraph 14 also, my lord, at page 828. However, the question in the present case is whether the interpretation provided to the contract in the award of the tribunal was reasonable and fair so that the same passes the muster under section 34 of the Arbitration Act. But kindly come to page A64 here, my lord. In the same punch, my lord, A64. This is again a judgment passed by Honorable Supreme Court, which could be seen at page A50.
A64.
I will refer to A64, but the cause title is at A50, my lord. A50. Anglo-American Metallurgical Coal Company Limited versus MMTC Limited. by Justice Nariman and
Nariman.
Justice Sinha, my lord. I am placing at page 15, the bottom, my lord, at page A64.
Yes,
Can I place it, my lord?
yes.
When a court is asked to interpret a document, it looks at its language. If the language is clear and unambiguous and applies accurately to existing facts, it shall accept the ordinary meaning. For the duty of the court is not to delve deep into the intricacies of the human mind to a certain amount's undisclosed intention, but only to take the meaning of the word used by him. That is to say, his express intentions. Sometimes when it is said that a court should look into all the circumstances to find an author's intention, it is only for the purpose of finding out whether the words apply accurately to the existing facts. But if the words are clear in context, the surrounding circumstances, the court cannot rely on them to attribute to the author the intention contrary to the plain meaning of the words used in the document. So my humble submission is that my contract very categorically speaks that the respondents are liable to make the payment of camp charges for outside maintenance, which will be carried out by the landlord. Can I come to page A293 in the same punch, my lord? 293. And this is again a judgment delivered by Honorable Supreme Court in Kharda Company Limited versus Raman and Company India Private Limited, which
Yes.
could be seen at page 284, my lord. I am referring a small portion of this at page 293, my lord. From the 7th line, my lord, if on a reading of the document, as a whole, it can fairly be deduced from the words actually used therein that the parties has agreed to on a particular term. There is nothing in law which prevents them from setting up that term. The terms of a contract can be expressed or implied from what has been expressed. It is in the ultimate analysis a question of construction of the contract. And again, it is well established that in construing a contract, it would be legitimate to take into account surrounding circumstances. Page 294, the next page, my lord. It is again a judgment delivered by the Honorable Supreme Court, my lord, in Enarkan India versus Enarkan GmbH. At page 294, my lord, paragraph 83.
Yes.
I'll just start from page 5th line, my lord, of the paragraph 83. In other words, a common sense approach has to be adopted to give effect to the intention of the parties to arbitrate. In such a case, the court ought to adopt the attitude of a reasonable business person, having business common sense as well as being equipped with the knowledge that may be peculiar to the business venture. The arbitration clause cannot be construed with a purely legalistic mindset, as if one is construing a provision in a statute. You know, the statute is defined in a different manner and commercial conditions are defined in a different manner. We may just add here the words of Lord Diplock in so and so, which are as follows. If detailed semantic and syntactical analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense. Paragraph 26, my lord. What is required to be gathered is the intention of the parties from the surrounding circumstances, including the conduct of the parties and the evidence such as exchange of correspondence between the parties. Now, my lord, I have delivered them bills regularly. I have claimed my payment regularly by letters and by emails. That also few of them I have disclosed in the proceedings. I have placed before your lordship also, my lord. Similar position of law was reiterated in Nandan Boy so wherein this court observed inter alia as under. The same thing, my lord, more or less the same thing. I am not placing all this. Then again, my lord, the same was 326, my lord. This is again a judgment of Honorable Supreme Court, which could be seen at page 322, my lord. Union of India versus DM Reverie and Company by Justice Bhagwati, my lord. Bench is Justice Bhagwati and Justice Murtaja. I am referring a few lines of this judgment at 326, my lord.
Yes.
Right at the top, my lord. It must be remembered that a contract is a commercial document between the parties, and it must be interpreted in such a manner as to give efficacy to the contract rather than to invalidate it. It would not be right, while interpreting a contract entered into between two parties, to apply strict rules of construction which are ordinarily applicable to a conveyance and other formal documents. The meaning of such a document must be gathered by adopting a common sense approach, and it must not be allowed to be thwarted by a narrow, pedantic, and legalistic interpretation. Why I'm placing all this, my lord? Because I wanted to establish here that it was only a commercial contract, it was not a statute. It has to be understood in that language only. Commercial sense has to be applied. When I'm providing the services, be it electricity supply, be it water supply, be it CAM charges, when someone is getting benefit, he must pay for that. There's a few judgments, my lord. I'll place few more judgments also, my lord. 827. In the same, my lord, 8279, my lord.
279.
279, my lord. It is again a judgment of Honorable Supreme Court, which could be seen at page 276, my lord. Bharat Coking Coal Limited versus Annapurna Construction.
Annapurna.
I'll place a small portion of this at page 279, my lord.
Yes.
The second para, my lord. There lies the clear distinction between an error within the jurisdiction and error in excess of jurisdiction. Thus, the role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties has given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction. Whereas, if he has remained inside the parameter of the contract, his award cannot be questioned on the ground that it contains an error apparent on the face of the records. There's 345, my lord, in the same bunch, my lord.
Yes.
The role of the arbitrator is to arbitrate within the terms of the contract. He is. It is there in paragraph 84, my lord.
84.
84. That starts in with an inverted on 22. The second line there, my lord. Thus, the role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties have given him under the contract. That Muhammad Jakir judgment I have delivered, I have placed before your lordship, the earlier one. It is not there in the bunch, my lord. There also it has stated as that if the reasons are such as no person of ordinary prudence can ever approve of them, or if the reasons are so outrageous in their defiance of logic that they shock the conscience of the court, then the court may interfere. Why I am submitting it, Lord? My Lord, there are express terms in the contract for payment of camp charges accepted by them. It should be understood in that line only.
Yes.
The Union of India Reverie I have submitted, my lord.
Yes.
And another is Kharda at 293, my lord. At page 293, my lord. I believe I have already placed it. Kharda I have already placed, my lord.
Yes, you have already placed.
That Anarcon also I have placed. Another judgment at page 353, my lord. 353. It is again a judgment by Honorable Supreme Court, my lord, which could be seen at page 348. Transmission Corporation of Andhra Pradesh versus M.R. Vemagiri Power Generation.
Yes.
I'll be referring to, my lord, page 353.
Paragraph.
Paragraph 20 and 28, my lord. This of the top two paragraphs.
Yes.
In the event of any ambiguity arising, the terms of the contract will have to be interpreted by taking into consideration all surrounding facts and circumstances, including correspondence actions to arrive at the real intendment of the parties, and not what one of the parties may contend subsequently to have been the intendment, or to say as included afterwards as observed in Bank of India versus so and so. 28. The true construction of a contract must depend upon the import of the words used and not upon what the parties choose to say afterwards. Nor does subsequent conduct of the parties in the performance of the contract affect the true effect of the clear and unambiguous words used in the contract. The intention of the parties must be ascertained from the language they have used, considered in the light of the surrounding circumstances and the object of the contract. And another beauty is the arbitrator himself has stated, I am entitled for camp charges in paragraph 18, my lord. At page 69 of my petition, volume 1, my lord.
Yes. In our page 12. Paragraph 18.
Paragraph 18, my lord. 1, 2, 3. 11th line, my lord. In other words.
Yes, got it.
In other words, rights and obligations of the parties were kept alive till then, with the consequence that the respondents in their term remained obliged to discharge their obligation to pay electricity charges, water charges, maintenance charges. Let me place the full paragraph, my lord.
To place the entire paragraph so that I can.
Anyway, all the aforesaid defaults and failures on the part of the claimant, even at any stage of the agreement, constituted breaches of the said agreement on the part of the claimant as a licensee. And by reason of any of such breaches, the respondents as sub-licensee were entitled to treat them as repudiation of the agreement and to determine the agreement by accepting such repudiation as to claim damages. They, however, did not choose to do so, but continued to occupy the scheduled premises and carried on their business until 31st October 2011, when they decided not to abide by such repudiation any longer and terminated the agreement by a letter dated so and so. There, my lord, I have categorically placed before the learned arbitrator, I may be a bad man. I may not have provided services. The respondents may not be happy with me, but so long they are in occupation of my premises, they have to pay rent. If they are not satisfied, they are welcome to leave my premises.
Yes.
I cannot restrain them from vacating the premises. But so long they are in occupation, they have to pay rent, come what may. Then the learned arbitrator stated all this. In other words, rights and obligations of the parties were kept alive till then, with the consequences that the respondents in their term remained obliged to discharge their obligation to pay electricity charges, water charges, maintenance charges, etc., in a mode or manner appropriate to the altered circumstances. The fact that the respondents did not exercise their option to determine the agreement by accepting any of such repudiation earlier did not, as a matter of law, prevent them to exercise such option at any time, which eventually they did by their letter dated 31st of October 2011. Meanwhile, such irregular relationship opened up the scope for many disputes. Most of such claims and disputes, in my view, did not arise or follow from breach of any obligation under the original agreement, but in consequence of their efforts to figure out some workable arrangement outside the scope of the original agreement, more so by way of a side wind. Such claims are therefore beyond the scope of present reference. That apart, in the context of unexpected and extravagant claims made by the claimant, I feel it right to make a general observation at this stage, which I have kept at the forefront as a guiding principle in consideration any claim for damages by either side. So here, my lord, what I wanted to humbly submit to your lordship, that in paragraph 18, it has been admitted by the learned arbitrator that I am entitled for payment of water charges, electricity charges, and camp charges. And then finally, he has rejected my claim. I have placed the minutes also before your lordship, my lord. I have placed the conditions of the contract also, my lord, before your lordship. And I just wanted to state, agreement has primacy over the arbitral tribunal's power. Agreement is the birth giver to arbitral tribunal. It is held at a high stature, and arbitrators must desist from deviating from the same. More or less, I have submitted. I just wanted to differentiate about that annexure D, my lord. Now, annexure
about the
annexure D, on which the arbitrator has rejected my claim based on that. Now, my submission is, my lord, there are express conditions in the contract for payment of camp charges accepted by the respondent. There is a specific commitment by their counsel before the arbitral tribunal that yes, I am liable to make the payment of camp charges. I rely on that judgment of Deepak Bhargav versus Jagdatani. I am placed before your lordship. When I am saying before the arbitrator, I am liable to pay this. Tomorrow I cannot deny that I know I won't pay. And annexure D, my lord, is not a prime agreement. The primary conditions are stated in the primary agreement. Annexures can display various consequences, various details, but it cannot create an express condition of a contract. And the agreement also clearly says, my lord, which has been erroneously stated by the learned arbitrator at page 135 of my agreement of my petition 2, my lord. It is very clearly stated in Annexure D, volume 2, my lord. Petition in volume 2.
One,
Page 135, my lord.
yes.
C6, my lord. There are 2 6, the last 6, my lord. Roman 6.
This is the Annexure D.
Maintenance, Annexure D, my lord. This is Annexure D. Annexure D to the agreement, my lord. C6, my lord. Maintenance and upkeep of all utilities whichever are provided by the licensee as per detailed specification scheduled at the cost of the sub-licensee. Now, what is there in the shopping mall, my lord? Shopping mall needs a daily cleaning of the common areas, my lord. Shopping mall needs daily supply of water. Shopping mall needs daily supply of electricity. And requirement is there for maintenance of the equipments also, like firefighting, like air conditioning, like electrical substation. So they have very clearly stated maintenance and upkeepment of all utilities which are provided by the licensee. AC plant has been provided by me. Electrical substation has been provided by me. Fire station has been provided by me. As per the detailed specification schedule at the cost of sub-licensee. Now, if it is a sub-licensee, it should be paid. Although
Yes.
I have not claimed anything on this account, my lord. I should have claimed. I should have raised heavy claim on this, my lord. I was absolutely a baby. I was a newcomer in the field, my lord. So now there is no reason that on annexion, the basis of annexure D, my entire claim can be defeated. And now, my lord, your lordship would remember Electricity Act. Now, Electricity Act, certain authorities have been provided to the Regulatory Commission and to Central Electricity Authority to make certain amount of regulations. Now, those regulations cannot be contrary with the Principal Act.
Yes.
Now, like that, my lord, annexure D is a secondary regulation. It cannot supersede the express conditions, my lord. And I have disclosed these the Supreme Court judgments also to that effect, my lord. In ITW Signod India, can I place it, my lord?
Now, today we have just out of time now.
And the whole problem is this is a voluminous thing. I am to place before your lordship all the judgments also to satisfy your lordship.
The fact I have understand everything.
Now, if your lordship has understood the fact, my lord, there's nothing remains there. This is a simple thing, my lord. I have provided them a space. I was liable to maintain outside, and I am claiming for outside, and I have showed them these are the charges. This is the basis, and you should pay for that.
Very well.
My lord, they were delivered the position on October 2007. Today is 25. Not even single pi has been paid on that account, my lord.
So, Mr. Surana, you have to take 1 day for that.
My lord, more or less all the judgments will be more or less common, my lord. And basically, my lord, all the claims which have been rejected are contrary to the conditions of agreement.
No, you have mentioned all the claims have already in there.
Most of the claims, my lord.
Most of the claims you have.
Number two, they are contrary to the law. And if these two things are there, your lordship has every right to set aside that award, my lord. And then I have to explain this why it is so. Now, take for instance proportionate cost, my lord. I have said very categorically in my agreement that they are liable to bear the proportionate cost of premium. Now, they have consumed some 8-9 sittings in the arbitral sitting and making different submissions. The law is very clear. My clause is very clear. They have to share the proportionate cost. I have shared High Court judgment also. I am entitled. I have shared the notification issued by the Regulatory Commission also that a consumer has to pay this.
Yes.
And that has to pay before the supply is made. Now, arbitrator says, Mr. Surana, you can reimburse only upon supply of electricity. No, he cannot rewrite a contract, my lord.
Very well. So, come on next week.
Tomorrow is probably holiday.
Next week, Thursday, 24th. Argument on behalf of Mr. Surana in person. Argument. কি ম্যাটার আছে এটাও রাখো এটাও রাখো argument on behalf of Mr. Surana in person hard in part. Let the matter appear in the list on 24th of April at 2 p.m. I have two other matters, short matters, that will take up your time.